Any mention?
My lord, I beg to mention item number 7, my lord.
Number
7, my lord.
Seven is what case? Fulbari.
My lord, we fix it after 2 weeks, my lord.
Okay, 2 weeks. Yes, no objection, I suppose.
No objection, Your Lordship.
Yes.
Supplementary list item number 1.
Mr. Sen, you are the briefing counsel here. You see, I saw article in the paper. I mean, these people who are approaching the court, the matters have been moved.
Yes,
how can they,
publish in the newspaper? It is newspaper. It is headline. Big,
article.
Entire petition has been
I was quite
published.
surprised because I'd gone to the file in the morning and I got the papers. I was looking. I said,
Entire petition has been.
not aware. I'm extremely sorry, my lord, because we are not aware of it. I'm extremely
otherwise,
sorry.
instead of it works. It'll prejudice your kinds of.
Absolutely. I mean, it is not, at least the lordships can take it, it's not under instruction. We do not know about it.
You can't make submissions through the media before the matters.
Absolutely, absolutely, my lord. This is a straight away apologies, my
has
lord.
been leaked. Not as entire petition is leaked, my lord. I have gone through the newspaper article in the morning and I saw that entire thing has been leaked. But be as it may, I am ready.
Our apologies, my lord, because this was never our intention. We do not know how it has happened. Nobody has informed us also about this. It should not have happened in all.
Jumping the gun.
Absolutely, my lord. Absolutely. It should not have happened at all. We are extremely sorry once again from both of us. We didn't know about it, my lord.
In spite of giving you concession of moving unlisted, yes. Anyway.
Yes, my lord. I'm extremely sorry once again for this. I'm also sorry to the learned Advocate General because this was never our intention.
No, of course, the counsel will not be counsel, but I mean, the people you represent, sometimes they
absolutely, my lord. No, it's our responsibility. We are representing the client, my lord.
See, not the fault of lawyers. At times,
Not the fault of lawyers. We can't
it's a client, but ultimately,
the
lawyers step into the shoes of client only. My lord. We step into the shoes of client.
Yes, my lord. I take responsibility for this, but I'm extremely sorry for this if it has happened. My apologies once again. I just take your lordships to this reason why I'm here before your lordships today.
Yes.
This is a system, my lord, the government of Meghalaya has introduced now. It's called the Integrated Excise Management System. Now, this system, my lord, involves, there will be holograms which will be attached to a bottle, liquor bottles individually. And on top of that, there will be a QR code which also will be attached to it. Now, the entire purpose of introducing this is perhaps, my lord, to control also the market as well as to have some kind of a regulation in regards to the sales or sales. Now, subsequent to this, my lord, there was a letter that was issued on 13th of August 2025 by which...
You carry a QR code to monitor the sale and movement.
Yes.
If
at all,
it should not
to
be
regulate the
spurious
business, my
also,
lord, basically
because
to
quality will also get controlled.
What is the purpose behind it?
Yes.
To check
To perhaps to regulate, you'll have the department will know what are the sales happening. They will also have to keep us that there is no duplicacy tomorrow. So the entire effort of the government is absolutely genuine in this. And I want to say this to your lordship that we are not against the implementation of the system at all. The only problem is by implementing this system, what they have done is, my lord, they have taken that the cost which is involved from our profit margin. So that is where it is hitting us. As retailers, my lord, we would have perhaps welcomed this as one of the most value system that is introduced.
Factor of fixing the hologram.
Yes, so that, my lord, has been introduced by a letter which they say that the cost will be ₹2.40. There will be an additional for the QR code ₹1.50, and there is a 50 paisa, which, my lord, we do not know why the purpose of it. It's called the additional revenue component. Now, we do not know why is this been imposed because it's not been clarified in the letter. It only says this is the component. Now, the component is divided into three factors, my lord. The first factor is ₹2.40 plus GST, which implies that it is a service which they are giving. The moment GST comes into it, because it's ₹2.40. So if it is GST, my lord, then excise, as your lordships are aware of the fact, it is basically to a production or a manufacturer or a distillers. So the first aspect that looks to be considered is whether this would amount to an excise levy. Because you are The bottle is already manufactured, seal and everything is done. The hologram is put on top of it and then the QR code. So technically speaking, as your lordships are aware, there is a central bond which will perhaps from the manufacturer come there. Then it comes to the bonds and then it goes to the retailer and then to the consumer. So there are 4 components which are involved in this. What they have done is, my lord, bypassing the first 3, 2, they have put this burden on us by reducing my profit, which was nearly 20% in 2017, now bringing it down to 15%. That cost difference, my lord, we have tried to project it in the petition.
So, Fukan, that means this is a uniform application, all bottles.
Absolutely, my lord.
Doesn't matter.
Absolutely,
Small
absolutely
bottle,
uniform.
bottle.
I said in the beginning, my lord, I have absolutely no problem with the policies implemented.
It comes in to common knowledge in different, like in 2 types or 3, I mean like the size.
Yes, madam.
So it's a uniform rate for
uniform.
small, big.
Yes, madam. It's a uniform rate, and every bottle, single bottle, every bottle who will have to implement this. The entire chain, from the manufacturer to the bonds to the retailers, everybody has to go and enroll themselves. The system, as I said, my lord, we have absolutely no problem, provided we are not being put to burden from my profit, because as your lordships are already aware, the business is anyway coming down, is narrowing down in regards to profit, where initially there were 20 shops, now there are 40 shops. In 2017, when the percentage was kept at 20, the MRP, there was a purpose, and during the circumstances it was put. Today, after 8 years, my lord, everything has increased. Cost has increased, there's a labor cost, there's electricity cost, everything is inclusive.
Just carry on, we see the components.
Yes. So in terms of that, my lord, this has been divided into 3 components. Subsequent to this, there was an amendment done on 12th of September 2025. In that amendment, in 372, which is under Article 21 and 39, which is the Act, which gives them absolute power to do that, because we are not questioning that power of the government at all, and has now brought this amendment from 2017-20 to 15%. I am aggrieved basically by this policy that you cannot reduce my profit margin. That is my case, my lord, nothing else.
In liquor trade, you don't have any vested rights.
No, I may not be, my lord. It is a fact that liquor does not come under the fundamental rights. However, I am running a licensed shop, license given by the government of Meghalaya. I have a right to be protected. I am not saying that don't collect this revenue. You can collect this additional cost, whichever in form of it's an excise or a fee that has been imposed. I am saying, why me? Why the cost has been reduced from me when there are 2 other people who are also in the chain of business? I am not saying you impose it to them. I said there has to be some mechanism used.
Say that this cost is entirely you're saddled with retailers.
Absolutely, entirely on me.
Only retailers.
Yes, my lord, that's the problem. That's why I have come.
The central bond or the
nothing. And had that cost been introduced as an incidence of my license, perhaps, my lord, I would have never come to your lordships, because I would have had no option left. This is not an incidence to my license. Because I am protected by them, by a license, I come under the...
You said 12th September?
Yes, my lord. First, may I take you to the letter, because that is extremely important. That's 13th of August, my lord. That's at page 66. I have a typed version of it because the other one is not very clear. This is, my lord, at the bottom you can see been issued by the Deputy Commissioner Excise Meghalaya. And this is a letter of 13th of August, my lord.
Yes.
The subject is Integrated Excise Management System Application and Matter Regarding. Yes. With reference to the above, this is to inform you that the department has signed an agreement with CMF Infosys LLP for implementation of the IEMS with a QR code label in the state of Meghalaya. In this connection, the department has fixed the cost of the IEM application at the rate of 2 rupees 40 paisa only, plus GST, and the hologram with a QR code at the rate of 1.5 and plus 0.50 paisa as a revenue component. Now, as I said to your lordships, we do not know what is this revenue component. I think my learned Advocate General will perhaps be in a better position to explain. In this regard, you are hereby directed to submit the cost card accordingly to the Commissioner of Excise Meghalaya for further information in regards on 18th of August. Now, that cost card, my lord, is available in terms of that notification which is subsequently issued at page 83, my lord. So this is the format cost card which has to be submitted. Page 84 is the relevant part. Your lordships will see brand name, size, ex-distillery, central bond margin 6%, landed central bond warehouse, bond margin, ex-bond, so-and-so, VAT, total margin now has been reduced to 15%. This is what we have to submit. And then there is a lifting price and the cost of the MRP. So by introducing this I'm saying as a fee rather, because I'm still not sure it will be an excise because it is on a service and not on a production or a manufacturing unit or a bottling institute tomorrow, because by the time the hologram is annexed, the bottle is already done. So the manufacturing process is done. I have no role to play in this. I only buy the stuff as a retailer and I sell it. There could be a medium or a system by which it can be passed on to the consumer. I do not know, my lord. That is for the government to decide. But to alone say that I am responsible it may not be permissible. Now, my lord, will come to this notification of 12(9), my lord. This is at page 79, my lord.
This is come down to 23. One thing, Mr. Fokan, remember, this annexure 14.
Yes, madam.
Is this 84 independent of the next page?
Yes, madam. That is the cost.
Part is 84th part of which annexure?
No, madam. That's a separate annexure.
84th part of which annexure?
This one, the first letter, my lord, which is at page 83.
Okay.
Yes.
Yeah.
Yes. 84, my lord. 85, my lord.
85 is the price of 2020.
Which is going on with 20%.
20%.
So this is the cost which is now going on. And one of my prayer before is, your lordships, that if the 20% is reduced to 15%, the implementation of the cost would be extremely difficult on us, because I'll not be able to recover it.
12.
Per bond. Yes, my lord. Now page 79, my lord. On the top, my lord, in exercise of the powers conferred under section 36, read with section 21 of the Meghalaya Excise Act, as adopted by Meghalaya, the governor of Meghalaya is pleased to make the following rules: amend the Meghalaya Excise so and so, hereafter referred as the so and so. This is the rules 2025. My lord, will come back to the next page, my lord, at page 81. The amendment is in the rule is amendment to 372 on the top, my lord. The principal rules on the 372 for the clause following so and so, the kinds of liquor and the maximum percentage of profit margin be revised on the retail sales as below. And this is the 15% that have been cost. Now, the 20%, my lord, is the first annexure of so and so, which is at page, in 2017, it was first introduced, my lord.
Yes.
What is it, 2020? Yes, my lord, that's at page 42, the 2017, which was introduced on 8th of May, my lord. In exercise of the, may I read, my lord?
Yes,
in exercise of the powers conferred under 36 of the Meghalaya Excise Act, adopted so and so, the governor of Meghalaya is pleased to make the following amendments in the rules of so and so. Then your lordships will come to B. The amendment is 372, the same amendment that happened then. And at B, my lord, the kind of liquor and maximum percentage of profit allowed.
Page 81.
Yes, my lord.
Same thing.
Yes, my lord.
There's 20%, 15%. Right?
That is the 20%, what I was trying to show, my lord. And this is the 15%. 15%.
Same thing. Wine,
yes, my lord. Same, correct. So the 20% has now gone to 15%. So that's my grievance, saying that you cannot take it from my profit. And I repeat.
Yes.
And there's no justification also to that, to bringing this policy on record.
Yes, Mr. Advocate General.
Yes, my lord.
What is the purpose
Yes,
in saddling them with?
Yes, my lord.
And first thing, I mean, without going to the other judges of this court. Now,
Yes.
central bond margin is only 6%.
Correct.
Right, and then bond margin is 8%.
Correct, my lord.
Before there was only one margin, is the bond. That's
No,
8%, right?
my lord.
Earlier on, I'm saying, earlier on before central bond came.
Central bond came. The issue was, my lord, that they were a retailer. They were having retailers margin.
No, it's not that. It's just an overview.
Yes, my lord.
Is that now central bond, as per this format of first card, central bond 6%.
Yes, my lord.
Bond margins 8%.
Yes.
And then it comes to them, and then now they are deducted 5% of their
Yes, my lord.
profit margin also. Yes.
Let me explain what is this margin, my lord. The prices of the bottle liquor is fixed, taking into account margin of each person, each individual. Each in the chain, there are 3 chains. In the chain, my lord, in supply chain, we have got central bonded warehouse, we have got bonded warehouse, and retailers. So far as central bonded warehouse is concerned, it is up to 8%, my lord. It is not minimum of 8%. it is up to 8%. Because these are the market dynamics with the.
The only thing is that why are you saddling only one segment?
I'm coming.
With this,
I'm coming.
5%? Why can't you stagger it with the?
No, I'm coming.
With the central bond and with the retailers?
Because the question, which if your lordship, they are saying that we are saddling them with this liability. The question, we are putting it as part of MRP, my lord, in the chain. If your lordship has changed, this is the cost card. In cost card, this is the chain in which everybody.
So you're reducing their margin.
Yes, my lord. Now,
That's
question
the
is.
main case that
Yes, they are saying. Now the question is.
They have no quarter policy.
Yes, my lord. So now the question is whether.
But then the only thing is whether like you are
from
right
20 to 15%
in targeting them. Also.
Yeah, no, I'm not targeting them, my lord. The question is, question is, my lord, whether I have a right to reduce the margin or increase the margin or reduce the margin or not, and whether this will be subject to judicial review, whether the government has power to vary the margin or not. It's like tax, my lord. These are revenue generation measures. If I can show, my lord, the order of this on division bench, my lord, after we have introduced the bonded warehouse, my lord, the sale has increased manifold, my lord, and that factor has been, if I can place, my lord.
No, we're not going there.
Because that is, see,
the only thing is that, you see, the only thing the school examine is that whether the policy decision,
yes, my lord,
making process,
yes,
will be under judicial review.
That is first question.
Saddling or the incidence of tax will, fall only on them.
Yes, my lord. See, so far as the legal position is concerned, the law is very clear, my lord, that like the higher bracket person are being charged by 40% in income tax. Whether it is subject to judicial review, why not 20%? Why not 5%? Why not this? So this will not. This is, my lord, settled law that it is not subject to judicial review. How much?
Okay, earlier on you had a hologram. It always come to the hologram. Where did that? Who paid for the hologram?
End user.
Yeah, end user, my lord. End user.
Consumer. End user.
Consumer, my lord. Ultimately, at the end of the day, my lord, it is consumer. What they are saying is that they, because of reduction from 20 to 15%, their margin is getting squeezed. But if the sale has increased 3
no, they can't add that to MRP, you see.
So now the question is, my lord, whether it can, if your lordship will come to the impute, there are 3 letters which have been placed before your lordship. Kindly see first prayer, and then I will show these letters one by one, my lord. Kindly see prayer.
We understand, Mr. Arvidas, all. We want to understand the thought process behind.
Yes,
why you're saddling like only one segment when
no,
there
it's
three,
not because
when there are 3 players
no, my lord,
involved.
earlier there was no
will make one profit.
No, my lord.
Margin.
No,
then why don't you reduce 1%?
No, my lord, we are not. Also? There is no minimum guaranteed margin to any of the.
There's no question minimum guarantee.
Yes.
There's no question.
They cannot charge more than 15%. They can, because if they are selling it, 10,000 cases, my lord. One retailer is selling 10,000 cases. He can say that and he can go to the bonded warehouse. He can go to the manufacturer, give me lesser margin, and so therefore this is a cap, my lord. It is not that you will in all cases get 15%. You may get 10%. It is a bargaining power between the supplier and.
We understand that.
Yes,
but the thing is that once an MRP is given,
yes,
now if there's additional cost to which they have to bear.
Yes, my lord.
That is the only thing.
It may have the impact of reducing their profitability. That is the bottom line. Yes, my lord. If they have, my lord, with greatest respect, if they have if it impacts their profitability, my lord, your lordship has said that in liquor trade nobody has right to earn the profit. Liquor trade, if the liquor trade is different, my lord, with the other right to it. Yes, my lord. So then your lordship will have to apply the parameters with respect, my lord. Your lordship will have to apply the parameters. Yes, my lord. First, kindly see. Let me place my case. Then your lordship will hopefully appreciate.
Trying to clear the.
Yes, I understand. Yes, my lord. Doubts which are there. Yes, I understand. That's a part of discourse, my lord. Kindly see the prayer, page 35, my lord. First prayer is, your lordship will mark, a writ in the nature of certiorari ought not to be sued to set aside the impugned letter bearing number so and so of 13th August 2025. So your lordship, the first prayer is 13th August 2025, and that later your lordship. Then second prayer is, my lord, also of setting aside of 12th September 2025 on next page, my lord, which is at page 80, and third is also, my lord, setting aside of the letter of. So these are the three documents which are assailed before. These are 3 orders, my lord. Kindly come to the first one, 65. Your lordship will find at page 65. And typed copies at 66.
Yes.
With reference to the above, this is to inform that the department has signed an agreement with so and so with IM and QR code level in state of Meghalaya. In this connection, department has fixed cost of IM application at rupees 240 plus GST and hologram with QR code at the rate of so and so per paisa as revenue component. Now 50% my friend is saying revenue component. So I am earning revenue because this is my right to earn revenue. In this regard, you are hereby directed to submit cost card accordingly. My lord, cost card accordingly. So probably in the cost card, these factors will be taken into account because MRP is fixed on the basis of cost card, my lord. I will take your lordship to the cost card.
So you mean to say MRPs have been fixed now?
No, because MRP is fixed taking into account cost card. Once I show the documents, your lordship will be clear. Kindly, I will just read it slowly, my lord.
Yes.
Plus GST hologram with QR code at the rate of so and so only and as per revenue component. In this regard, you are hereby directed to submit cost card accordingly to Commissioner Excise for further necessary action on or before 18th August. My lord, this is the first letter which is sealed before your lordship. Now kindly come to this, the page, your lordship will come to 83, page 83. And before page 83, my lord, second thing which is challenged before in this writ petition is 79. So first I will show, my lord, 79, the rules, my lord. 79, because ultimately these are the, this is dated, my lord, 12th September to, this is also challenged. This rule is also challenged before your lordship. And in exercise of power, my lord, notification is of 12th September 2025. In exercise of powers conferred in by section 36, read with section 21 of Meghalaya Excise Act, as adapted by Meghalaya, the governor of Meghalaya is pleased to make the following rules to further amend the Meghalaya excise rules as adapted by Meghalaya hereinafter referred as. And then, my lord, kindly come to paragraph page 81, my lord. This, which is under challenge before your lordship. Page 81, the kind of liquor, rule 372 is amended, my lord. In principal rule 372 in sub rule 1, clause B, the following shall be substituted. Kind of liquor, beer, all kinds of including beer, maximum percentage. So this is the maximum they can ask for, my lord. This is the, earlier it was 20%, now it has been reduced to 15%. Now second, then, my lord, kindly see the third letter at page 83, my lord, which is under challenge before your lordship. All bonded warehouse, central bonded warehouse, companies, breweries, bottling units, state of Meghalaya, please find enclosed herewith copies of government notification dated 12th September, which are self-explanatory for your information, necessary action, format of cost card. If your lordship will see the name, brand, size, my lord, central bond margin 6%, landed to central bond margin 8%, X bond fee, import fee, literage fee, ad valorem, VAT, total 15% margin, retailing lifting fee, we are giving them retailing 50, MRP per case, MRP per bottle. So this is how the price is fixed every year before, my lord, the bottle is lifted or sold by or to the consumer. So this is the mechanism in which the cost is being built. Now the issue before your lordship in my humble submission is whether the state government in exercise of amendment to statutory rule has power to fix the margin or not, and if it is arbitrary or illegal or per se against the law, my lord. These are the some of the issues my friend has raised, my lord. Before I take your lordship to this, my lord, kindly see, because this was also the issue before division bench of this honorable court, my lord, and where the issue arose that what has happened and what is the
understand this cost card. So that means the central bond margin, X bond.
We'll file detailed affidavit, my lord. Placing
X bond.
Yes, my lord.
Out here, like in the old rates. So suppose there's just look at this extra strong beer, whatever.
My lord, we have reduced the margin in respect of everyone. That the amendment
No,
which
before, I mean,
before
when
there was in bond margin was
before the amendment, what was the
my lord,
what was the
that
margin?
I'll place it, my lord. If you lordship will see the amendment
What
which
was
I have.
maximum margin for the central bond warehouse and for the bond?
This bonded was unlimited. There was no cap. CBW there was
Before
no,
the
and
amendment.
before them there was no cap. We have put it 6% cap.
And for bond,
Bond 8% was earlier also there, now also there.
8% was minimum.
8% was minimum. Minimum they could have gone. Sorry, 8% was minimum. They could have gone higher.
now 8% is maximum.
Max cap, my lord.
Where's that?
So, my lord, if you lordship will see rules which we notified at page 79.
With regard to the central
Yes,
fund.
I'll place that, my lord. Your lordship will see page 80, rule 44, my lord. Page 80. Rule 3, amendment of rules 44, my lord. In principle rule 44, the following shall be substituted, namely, maximum profit margin of central bonded bearer on their sale to bonded warehouse is 6%, shall be 6%, or subject to minimum profit margin of 65 per case, and for one bonded warehouse on their sale to retail IMFL or off and on license shall be maximum profit margin of 8% and subject to minimum profit margin of 50 per case, wine bottle, etc. So this was, my lord, earlier.
What will be the impact on the consumers?
The consumer, my lord, what we have seen, my lord, that there will be minimum impact. And why we say so, my lord? Because we have placed the data before the honorable division bench, my lord. And if I can show the data, my lord.
Only one thing, the thing is that you see, this liquor in Meghalaya is a very important source of revenue.
Yes, my lord, that is
We got teachers from there.
we can't impact our revenue, my lord, by enhancing our margin. Your lordship is absolutely right that we can't do that. My lord, kindly see.
Just an observation, yes.
Yes, your lordship is absolutely right, my lord. That liquor business, if your lordship will see after the policy which we have amended, kind of sale has gone phenomenally and revenue has also increased. My lord, this data we place.
That's not very healthy then, is it?
What to do, my lord? These are sin goods, my lord. These are sin goods.
Good, bad.
These are sin goods, my lord. If your lordship will see the decision of the at page, particularly, my lord, yes, my lord, the data page 19. Because the after this, my lord, the sale Imperial Blue, my lord, in 2021 it was 66,298 cases. Now is and ultimately this has gone to 4,68,500, my lord. So revenue, the if there is a more sale, my lord, they are getting more profit and government wants to earn some money, my lord. I will put affidavit, my lord. Giving all the.
Has it been implemented?
Yes, my lord, it has been implemented, and I am covered. And two more aspects also.
Integrated.
Yes, my lord. Yes, my lord, and this is a revenue matter, my lord.
IEMS.
Yes, my lord, and hologram was also earlier there. Now, my lord, so far as one aspect, two important aspects which I want to place, my lord. That this is a by way of association, my lord. So associations have no right under Article 19(1)(g). Because now legal, these are the two, the right to trade in liquor is not available, my lord. Lordship will see Khode Distillery Constitution. Khode Distillery, so they have very limited right, my lord. Very limited right, they can't question it, my lord. Now, the same issue, so therefore, if they can't question in the liquor, if I can place, my lord, Khode Distillery for your lordship's kind consideration.
No, coming back to this point regarding Amendment Rule 44.
Yes,
you're saying that this amendment is affected across the board.
Yeah, across.
I mean, the central bond, the bond, and the
yes,
retailers.
Yes, my lord.
And with regard to retailers, only 5% reduction.
Yes, my lord.
In the maximum profit that
yes,
you can derive.
Yes, my lord.
From the sale.
Yes, my lord. It is up to them. In some cases, they may be, because if they want to increase sale, they can reduce the price. It is for, these are all the business dynamics, the dynamics of the trade, my lord. Therefore, whether these will be, and this issue, my lord, is subject to, if your lordship will see the direction which is passed by division bench in this matter, kindly see, my lord, division bench order. Yes.
Just basic.
Your Lordship, there are directions passed.
Second, yeah. Okay. Yes.
Yes, my Lord.
I think we'll need an affidavit.
Yes, I will place the affidavit, my Lord. I will place the affidavit, but this is not.
And
Just only one small request.
And this is not a case.
I think, Mr. Fukan, before we'll consider the interim pay on the next date, we'll have a short date. Let them come and affidavit. Let them come on
my Lord,
record.
is not maintainable in this case, my Lord. In any matter, my Lord, Dunlop Agro is covered. I will place that judgment on next date of hearing, my Lord.
May I just, Madam, one, she will obviously put in an affidavit and clarify everything else. In regards to the dynamics of the business, my Lord, would you not just be kind enough to, in my petition, I'll just take 2 minutes, my Lord, just 2 minutes. I won't trouble your Lordships. I have at page 23, my Lord, I've given a comparative table. Now, I am on the business of, as my Lord Advocate General said, in regards to the business survival. My Lord, we'll come to the table on 23. Your Lordship sees this is 20% and 15%. I've made out a table to say the cost involved in it. So it starts from purchase sale, selling price, margins, license fee. The differences all have been quoted. If your Lordship come to the next page, my Lord.
Yeah.
The last column, 12,
Yeah.
is gross margin. It is 7.9% with 20 and is 2.79 with 15, with reducing it to 5%. I could have understood if it was in regards to extracting money qua one particular floor of a trade. This is killing a trade, my Lord. 2.79, what business logistics can I have tomorrow to survive on it, my Lord?
Number of the cases which they will sell, my Lord. They are making it very simple.
The entire purpose of 372 is to make sure that the neighboring state doesn't get that benefit. They want to keep the price below it. That's the difficulty I'm facing, my Lord, today.
My Lord, they kindly see.
No, you see, one thing we have to examine is whether it's a rationalization across the board with regard to central border warehouse, the bonded and the retailers, or whether it is, there's some arbitrary decision on the part of the respondents whereby they have burdened you. With, that's the only thing.
Only thing I'm requesting, my Lord, is they will obviously file an affidavit, but the new price is still not come. At least till then. Otherwise, this entire effort is
kindly hear me, my Lord.
Only in regards to that.
One more objection, which I have a serious objection. This is a petition filed by association, my Lord. This is a petition filed by association. Now, the law on the association is, my Lord, that what happened in electricity matter, your Lordship has seen. In electricity matter, what they do is this is only confined to one district of Iskachil Wine Association. We have got other districts also. What happens, my Lord, they will come and retailer will come separately, the association will come separately. For this reason only, my Lord, in the Madhya Pradesh High Court, and we should follow the salutary practice, what they say that you have to give me the undertaking from the members of the association that they will abide by the judgment of this honorable court. May I please that in respect of association, my Lord.
No, but then this is not a material.
I'm only saying till then, till they file the affidavit. That's all I'm saying.
Is, my Lord, that kindly see the Dunlop judgment, my Lord, on interim relief. On Dunlop, my Lord, kindly see the Dunlop, because what they are saying is, my Lord, is in Dunlop.
No, unless the court satisfied, we will not pass interim orders. Right now, we're still not.
Yes, my Lord. So therefore, Lordship here.
Fix it after 1 week. You put any objection.
Yes, my Lord. After vacation, then 1 week will go.
After vacation?
Yeah, after one vacation, then we will.
The only thing is, your Lordship will remember that once the price list comes, it is a per bottle. I'll never be able to recover it. Never.
Yeah, my Lord.
This is a harsh reality. Let us face it.
No, this is the question. This is the question of impacting the revenue, my Lord.
It depends. It depends on them whether they let the responsive fall. Interim orders, we don't think there's a strong prophetic case, because it was across the board the reduction as we've shown that amendment 44. So that otherwise, if the burden is entirely on you, then maybe.
And even in that case also, my Lord, the burden is on in that case also, my Lord, they are not entitled to.
Exercise looks to be entirely on us.
The R.K. Fukan Leonard Counsel for the petition issue notice. the Alden Advocate General is present with Mr. Pandey. On behalf of all respondents, no further is called for. As the matter, though a prayer has been made for passing interim orders at this stage, on the ground that the proposed action of the state respondents will impact the retailers and curtail the profits, in view of the circumstances, the state respondent is directed to file an affidavit within 1 week. The matter shall be taken up on reopening this for consideration of interim prayers.
Would you also just be kind enough to fix it?
I will,
Yes.
7th, your lordship, may have it on 7th, my lord. I will file the entire counter
An
affidavit.
advance copy.
And advance copy, my lord. I will file advance copy and everything, my lord. And lordship may have it on 7th.
May I just request 9th if it is not in
Yes,
inconvenience?
no.
Extremely grateful.
We always, yeah. Yes.
Extremely grateful, ma'am.
Daily list item number 1.
Mm-hmm.
Lord, this matter will go before the
Take it tomorrow.
yes, to take it to your lordship.
This is matter tomorrow before the division bench number 1.
Yes.
May I please?
Item number 2.
1 second. Let the file come.
Yes. Yes, my lord. Service report is still waited, my lord. We have right to the post office and on 19th.
How many respondents?
My
7,
lord.
8 and 9.
Yes, my lord.
Yes.
7, 8, and 9. My lord.
Officer indicates that service is not complete on the respondents 7, 8 and 9.
Yes, my lord.
So upon post this matter on.
After 2 weeks, my lord, we'll
After
file service
Puja,
affidavit.
Yes, vacations for service report. Drop the learned counsel petitions are permitted to a certain status
My lord.
and file affidavit if necessary.
My lord. Highly obliged. My lord.
Item number 3.
My lord. My lord, they are to file the affidavit. My lord, I crave your kind indulgence, my lord. Can you grant some time, my lord?
Who's appearing in this matter?
My lord, Mr. N. Sincon is reading them.
Yes.
My lord,
You enjoy interim order. Anyway, let's further 2 weeks as prayed allowed. Interim order shall continue the next date.
please do right. Blessed.
Hearing. Item number 4.
The file.
Yes, Dr. Mazika.
It is for written submission.
Today,
Dr. Saraf has served a copy to us, the filing code.
where's Mr. Saraf? No, this is JB Textiles.
JB Textiles.
Because last time we submitted that's slightly different from
Correct.
the other mega.
No, Dr. Saraf has 2 matters, my lord.
So one matter is 15 days, but we are not passing judgment as yet because we want to finish off the matters. Then maybe we can cover one judgment. Otherwise, we have to render separate judgments. Yes. Yes, Mr. Sharma. He's not appearing.
Lordship, Dr. Saraf is out of station, Lordship. So for item number 5 and 6, Lordship, we seek some accommodation in as much as we seek an adjournment, Lordship.
I went through these 3 matters because last time it was I read it in the night. So no issue. What if it's not there now?
Yeah, the Mazika.
But
Okay.
JB Textile is, my lord, JB Textile, my lord, is similar matter. It's a similar matter, my lord.
I'm relying on Dr. Saraf's
You
submission.
ticket when? When was Dr. Saraf?
After vacation,
After vacation.
here we have vacation
Yes. Till date, give the date.
in November 1st, Lordship.
You will forget the argument which has been advanced.
Yes.
No.
November 1st, okay. On the due to unavailability of Dr. Saraf.
So only the interim order.
Milord, in tax matter, Milord, this is a tax matter, Milord, revenue matter. You Lord have seen Dunlop judgment, Milord. In revenue matters, it is impacting revenue. That is the issue. I am only concerned with that aspect of the matter, Milord.
Yes, for all assessment years.
But still, revenue, and they have evaded, Milord. I have shown they have evaded. They have evaded huge amount, Milord. That is there, Milord.
First is assessment.
First Saturday. Then, where's November?
Which calendar?
3rd November.
But the interim order.
Monday, Tuesday.
4th November.
Obliged, Lordship.
The interim order.
Interim order for any certificate.
Interim order, Lordship.
Item number 5. Item number 5.
Item number 5, Dr.
Yes, 5 and 6.
6.
5 years, 5 years.
5 and 6.
5 and 6.
Interim is in 6, Lordship.
Yes.
There is no interim in 5. There is no interim in 5.
5.
Only
6.
6.
There is,
Only 6. Yeah.
6. Obliged, Lordship.
Okay.
Item number 8.
Please, Lordship. Lordship, due to the agitation, we are trying to settle it. I have just been informed with some letters.
Where's Mr. D?
Lordship, he has just gone to the bar because of some personal issues, Lordship. Otherwise, he's available, Lordship.
See, one thing, Mr. RK General is here. You just want to flag one issue.
yes, Milord.
This time I had gone, I had gone on inspection tour and to Garville's, the entire thing. And while in Tura, the lawyers association came and asked for audience and met me with a memorandum. I'm just sounding you. The thing is that district council courts have not been functioning from June because of salary problem. It's been shut, and
Yes,
litigants are suffering. The lawyers are suffering.
In fact,
And the thing
PIL,
is that another aspect is that the Secretary Reserve Committee is serving the judge also. So under the government explosion, you separate the executive judiciary in the district council also.
yes,
It
Milord.
has to be done. You can't have an
Yes,
executive,
Milord.
you can't have Secretary Reserve Committee sitting with the judge.
The problem which we are facing, Milord, your Lordship has seen in those transfer petitions also. Problem is that the power to constitute the council court is with the district council only.
Fine, but the thing is that at least it should come, from the government district council.
And there is a PIL
There
also.
should be a separation, at least in the district council, like it's done in Khasir and Jainte Hills, separation of the executive from judiciary. There, the executive, he is the secretary of the committee, he is the judge of district council court also.
Yes, Milord.
How is that possible? Last time this court
No, no.
observation, that case is,
Yeah,
I think reported
one
also.
PIL has been filed.
Then they had
Yes,
corrected it, but again the same thing has been
No,
repeated.
what has happened, Milord, separation has taken place here also in executive and judiciary pursuant to the orders passed by the Honorable Supreme Court in All India Judges case, Milord. One PIL has been filed, Milord.
No, I'm talking district council. I'm not talking about the state. Separation within the district
Yes,
council
my lord.
itself.
So, because, my lord, the problem, if your lordship
cannot
has,
suppose this-
paragraph 6, your lordship has seen, paragraph 6, your lordship has seen, there are certain powers which are vested with the district council. It should have been done by district council.
Exactly,
I can
but
advise,
then-
we
but
can,
then
as a
the
government,
thing
we
is
can
that
advise them, we can persuade them.
that is
We will do
looking
that,
like
but
it's for
we
the-
will request your lordship,
it's
because
for
there is a
absence of
PIL
justice.
also.
Otherwise, I will have to take it up tomorrow.
There is a PIL also pending. It's coming up tomorrow. No? PIL is coming up tomorrow, my lord. Your lordship may also.
At least ensure.
Yes, my lord.
One thing is that ensure the separation of the in the district council itself.
Yes, my lord.
We're not talking about state.
Yes,
We're
my
not
lord.
talking about the regular judiciary.
I understand, my lord. The difficulty, the constitutional.
to take sumo to, we'll have to take
yes, no,
sumo
my lord.
to.
Tomorrow a PIL is coming. One PIL has been filed, my lord, which is coming up for hearing. In that, the prayer is there are issues. Your lordship has rightly flagged that those issues are prevailing, and your lordship has these are dysfunctional. Those courts are functional. People are suffering. People are not
be
getting.
a total different look if district council courts are to survive.
Yes, my lord.
Now, if district in Jainte Hills,
Yes, my
from
lord.
reports, process service not been paid for 8-9 months.
Yes,
how
my
will
lord.
you go and serve notice?
No, my lord, what we have done is
And the
now
people are
we have
suffering?
come because the problem is that they are not putting their in-house in order, and now there is a proposal to them to have the administrative officers, IS, heading those secretarial posts. We have given those proposals. My lord, these are the political problems.
Different. That's totally different.
Because-
What we concern administration of justice.
Yes, my lord.
Now the thing you talk about justice.
No, this is also
if the
flowing
courts are
from-
closed, Mr. Dev, from June or from May.
Yes, my
they've
lord.
been shut totally.
No, my
I was
lord.
shocked that day when I went.
The entire court
And they
office,
came and madam
everything
said,
is
please
shut
do
down.
something.
No, my lord.
Now I'm the acting head of judiciary in the state.
Yes, my lord. PIL is
I
coming.
feel responsible.
PIL is coming
in
up
fact, I
tomorrow,
was
my lord.
embarrassed.
No, I understand, Milord. It's a
And some lawyers
genuine
depend
concern.
for entire livelihood
No,
on you know on the district council court.
No, we will again issue advisories to district council, Milord, and to the district
please
council
take
too.
note of
But the problem is that they are not, and we have been advising. But tomorrow PIL is coming,
You can't
Milord.
just you can't just wash your hands off.
No,
That-
we cannot.
that
I am not
district
washing,
council-
Milord, at all. We have, if I can place, Milord, we have taken.
As
In fact,
Advocate General,
I was.
you're the first law officer.
No,
of the
no,
state.
I was
You have
part of.
responsibility
Milord,
towards the district
no,
council
Milord,
also.
I was part of the meeting with them. I was part of that meeting process also, because they are not allowing the district council to function because they are not getting salaries. They are blocking everything, Milord. But my friend has.
But the court should function.
Yeah, and even courts, they are
board
no.
is shut, Lord.
The courts, everything. They even district council is shut, Milord.
And the thing is that from what I see, I said, why can't a court function at least? They said, no, because the person who's a judge, he's a secretary to the committee. He also is dharna. So what is this?
That is correct, Lord.
No, we have advised, Milord.
We'll go on dharna, so we will get paid.
No, Milord, we have advised the government. We have taken.
Mr. D,
My lord.
your lawyer friends, I mean, your brother community,
My lord.
while I was in Tura last
Tura, my
week.
lord. I was told.
It's embarrassing for us
My lord.
that if you don't separate your judiciary, separate executive from judicial side, at least in the council, that advice you give to your
My lord,
CM.
I'll take up the matter today itself, my lord.
Because the thing is that he said that, I said, why can't the court function at least? He said, no, but judge, last time, I think my bench had passed the order that it should be separated.
I'll take reference of this order, my lord, and I will.
Now, what I've done is that we said, no, can't function because the judge is the secretary of the committee.
I'll take up the matter, my
No,
lord.
no, I will place, my lord, the authorities on this aspect where this court will have, because we can advise. I am not washing my hand, my lord.
We have only when the orders come, in appeal or
Yes, my lord.
in revision.
Yes, my lord.
The thing is that how much can we throw to 235 also? Because out of Article 235.
But 227 is there with your lordship. 227 is, my lord, superintendence over all tribunals within the state of Meghalaya, my lord. And that power has been exercised by the Honorable Supreme Court while directing separation of executive from judiciary in all states, my lord. And I urge your lordship to exercise. We are in party to this, my lord. We will support and we will do that, my lord. We want that the efficient district council to function, my lord.
You are aware, Mr. D, since May or June, the
They are
court
not
is
functioning.
functioning.
Even district council is not functioning, my lord. District council is not functioning. That's
Yeah,
it.
whatever judiciary only, we bother about
No, but
litigants.
this is entire problem is entire the malice has been set in the entire the functioning of district council, which we are trying to address it. My lord, we have come out with the
I
proposal.
felt really bad for those people when they came. They said that this is the
Today
situation.
itself, my lord, I will take up the matter.
Because they said that we don't have a face to show our clients, and most of them are illiterate. They don't understand what a court functions. Anyway, what is they asked they sought permission to file a proper memorandum. I said, do that. You give it to Registrar General. We will take a call on it. Yes.
Hello.
This matter. Yes, Mr. Dev. What do you want to say?
My lord, here, my lord, I was communicated with a letter by the secretary where, my lord, they are saying that regarding the respondent here, my lord, in the appeal, we cannot take a call because of the again closing down of the. We're trying, my lord, to settle it.
Well, it doesn't matter. This other matter, you say that the number, that is number? Item number 8. That's it. Yes, parties pay that matter after 3 weeks allowed, yes.
Must first watch
Any mention?
May I please, Your Lordship? Your Lordship, I beg to mention item 30, Your Lordship. I've taken the consent from the other side.
30 for matter.
Respondent number 4.
Will come after 2 weeks, Your Lordship.
Oh, sorry, you took a supplementary list. What's this one? The same
It's
matter.
regarding the same. Actually, it
Why?
has become infractuous, Your Lordship, but they have insisted for a
After
hearing.
2 weeks, Your Lordship.
Okay, out of puja, we'll close it.
Just a
Highly object.
Wait, please, Lordship. I beg to mention item 14, Lordship.
Number?
1414. So here, Lordship, Senior Counsel has given a list of books. So I'm just praying, Lordship, we will go through it at one shot. We'll finish the hearing, Lordship, after 2 weeks.
At one shot?
I mean, in one hearing, Lordship. I'm sorry.
It is a part-heard matter, Your Lordship, and we were actually on the case laws, Your Lordship.
So they have supplied the list of books today. So I'll just pray for 1 week to just go through it. It may be taken up after puja and disposed of.
It's all right, Your Lordship, after pujas. I'm also told that the senior counsel is busy with some puja arrangements.
Who's Mr. Day?
Yeah, Lord, some.
Okay, yes. Out of puja.
After pujas, Your Lordship.
Lordship, I also have a prayer for item 15, my Lord.
Is that you don't want to go on study leave?
No, Lordship, here they have again filed a fresh affidavit. So we require to file a short rejoinder. I'm praying for 1 week, Lordship. We'll file the rejoinder. Kindly have it after 2 weeks.
2 weeks.
Lordship. Obliged.
Well, I'm praying for 18 and 19. After puja petition. No objection, Lordship. 17, 18, 19. 17 is it?
Yes, okay, 17, 18, 19. On the request of on the prayer of so-and-so after vacation.
What's obliged, Lordship?
Your Lordship, in item number 21, Your Lordship, we are filing an additional affidavit in course of the day, Your Lordship.
Yes, 21, MS Tiangi B. Lendi AG submits that the charge will be filed at course of the according list the matter after 2 weeks. Yes.
Obliged, Lordship.
Your Lordship, I also have a prayer for items number 24 and 25, Your Lordship. This is regarding the fixation of
Where's the petitioner?
We have been asked to seek some time till
Lord,
puja
we file an
vacation.
application for modification, my Lord. So let that application be heard.
No modification. We asked that let the state
Whether-
government approach.
Yes,
Yes,
my Lord.
that
That's
the
it.
government and in consultation with the High Court will
Yes, my
fix
Lord,
Lord,
but they have not approached the High Court, my Lord, through the Registrar General.
So, Your Lordship, we have just been asked to take some time for
Okay, well, after vacation.
after vacation,
You
Your
please come
Lordship.
back
In the
with
meantime,
something.
we'll do the needful, Your Lordship.
MS Tiangi Leonard, Senior Counsel, we have to respond submits that the proposal as indicated in the Mrs. application is being explored and assures that the response will take appropriate steps
Yes, Your Lordship.
by the next date. Yes.
Obliged, Your Lordship.
Please, Your Lordship. Lordship, I beg to mention item number 22, Your Lordship.
May I please, Your Lordship, item number 22 and 20, we both are connected matters, Your Lordship. But Mr. A. Momin is taking on the...
Yeah, I'm
is
seeking time on behalf of Adaya, Your Lordship.
He's unwell.
Lordship has been hospitalized.
After vacation.
Lordship, in item number 23, I'm the petitioner.
Obliged, Your Lordship.
Yeah.
So I beg to make mention for item 20, Lordship. This matter fixed it after vacation, Lordship.
20.
20, Lordship.
I'm there for district council, so I can answer it.
Lordship, we're ready, Lordship, this matter.
We'll take it up now.
Lordship, Mrs. Paul is not available, Lordship, today. Please say
You're
please.
there?
Lordship.
Yes.
This is
He had a brief with you.
Lordship, he has, Lordship.
Then
So we'll
you're
answer that.
objecting.
We have some queries, we'll answer them.
Which queries?
Regarding the authorization.
Lordship may fix it tomorrow, Your Lordship. The police will be there tomorrow, Your Lordship.
Some urgency.
Lordship, as the urgency, there's no
There's no
urgency.
urgency. Then if the petition no urgency, then
There's no urgency.
just set after
This is regarding that dispute between two boundary dispute between two same shape Lordship. Same Bhowal and Maharam. There is one village which is in dispute.
What
Lordship.
census?
The census, because they are collecting census, because now the inhabitant of Tongplang village not able to decide on which path they fall.
It's only with regards to that Tongplang village Lordship.
Then will it come tomorrow, Lordship?
Tomorrow, Your Lordship.
Just one issue to answer regarding the authorization.
Okay, tomorrow.
Lordship.
So, similar prayer for item 27, so, Lordship. 27.
27.
Lordship.
Yeah, objection.
27. 27, my Lord.
Okay, after vacation days.
Right. Supplementary list, item number 1. Item number 1.
Yes.
May I please, Your Lordship, Your Lordship? Yeah, I have preferred this petition, Your Lordship, for regularization and pensionary benefits.
Who are you?
I-
Regular employees.
Temporary status granted by this honorable court as per the order of this honorable court. Who has granted temporary status. Your
And how
Lordship,
can you claim pension then?
Your Lordship, as per the notification dated 7/11/2000, Annexure 7 at page 21, Your Lordship.
What is this?
Your Lordship, number 4, Your Lordship. 50% of the service rendered under temporary status would be counted for the purpose of retirement
After
benefit.
regularization. You're not regularized as yet.
So, Your Lordship, here I am praying for regularization before, because
Or for pensionary benefits.
regularization and pensionary benefits, both, Your Lordship.
Yes, so they're paying for new.
So, Nehu,
You accept notice?
Your Lordship, I'm appearing for respondent number 2, UGC.
You've received.
Yes, Your Lordship.
You accept number 1. It's heard MS Chaji. Then counsel for the petitioner issue notice. MS Amber Chang Vice, Dr. Mbuzeka is present on behalf of respondent number 1. MS S. Langste
Yes, Your Lordship.
is present on behalf of number 2. And MS Ibla Vice, Mr. S. Sends present on behalf of number 3 and 4. Such notice complete all respondents just after 3 weeks. For
Your Lordship, next case number 2 also, almost same, only dates and case number is different.
same order.
Much obliged.
Parties are the same.
Parties, 2 different parties.
Item number 3.
May it please, Your Lordship.
Yes, Mr. Dev.
Lordship, this matter pertains to the verification of my degree certificate. I was enrolled in the CMJ University for the academic.
CMJ, before any other bench without me.
All right.
Item number 4.
Yes.
Just Lordship. Yeah, I'm coming for regularization, Your Lordship, because initially I was appointed as a peon when the school was run by the district council. When the school was run by the district council, Garo District
Which
Council.
year you appointed?
It was appointed on the 15 April 1996. Thereafter, there was an act, Your Lordship, when the school, by the virtue of that act, the school was taken over.
Act came before 96 or Act not 94?
Not 94.
It was
96.
93, Your Lordship.
94 actually.
That act was 1993, Lordship.
93.
Yes.
It has come into
1993.
effect only from 94.
Yes. What happened then after that?
You appointed 96.
96.
By whom?
By the district council, the deputy commissioner, who is the administrator of that school.
Let's see your
Lordship.
Page?
Page 21. Page 21 is the type copy of this one, the Lordship. This is the appointment letter. This is the appointment of the deputy inspector of school, Ampati subdivision, school West Karhulsi.
Oh, okay. You are Glorita Sama.
No, I'm this one, Kiparson. In place of Glorita, I was appointed. This one, there is a second line in the vacancy course. Thereby, Sri Kiparson, Sangma SSLC appear. That's mine.
You take notice.
We'll take notice in
Let us PT Sangma, Leonard Council Petitioner issue notice. MSP Yang will be assisted by so and so, and which present as Sajno for a notice call upon the respondents. That's also 3 weeks for instructions / affidavit.
Your Lordship, this 5 to 7 is the connected matter, Your Lordship.
All of them?
Yes, Your Lordship.
Item number 8.
Much less, Lordship.
Similar?
Yes, similar.
But the date of appointment was different, Your Lordship.
Only date of appointments. Much less, Your Lordship.
Yes, Mr. Shraddha.
Your Lordship, I am appearing for item number 8 and 9. Both are connected matters arising out of the same judgment of this honorable.
What order was passed in the review application?
In the review, they had changed the sentence, a slight modification, which says we direct the appellants to remit to the respondent's bank account 17,16,189 being the value of the seized gold within 2 weeks of the communication of this order to be taken as an amount made over in lieu of the gold.
Yes.
Instead of returning of the gold, it has been substituted. This
Yes, so we have got the money now?
No, they haven't.
No, we have not.
When was the order passed?
It is passed on 1st September. 1st September.
When was it communicated to them?
Lordship, on 2nd September, I have communicated through via email. Then, after the expiry of 14 days, I have communicated by letter also, Lordship. And I have.
Where is that email communication?
Lordship.
September 3rd.
Yes, my lord, this annexure P2.
P2. Page 7.
Page number 17.
Dr. Musika, ensure compliance within 2 days, otherwise you will issue notice of contempt.
The matter come on Friday. Today is Tuesday, Friday.
Yes, heard Mr. Chadha. Issue notice. Dr. Musika is present, accept notice on behalf of both the respondents. No further notice called for. Stop the complaint of the petitioner is that in spite of the order dated
1/9/2025
passed by the division bench of this court, wherein the respondent directed to remit an amount of rupees 17,16,189 being the value of seized gold within 2 weeks of communication, the same have been complied with. Stop. Dr. N. Musika praised and appropriate instructions. It is further observed that in the absence, if there's no compliance with the order before the next date, notice of contempt will issue to the respondents. Yes, yes, on Friday. So give me a chance. Otherwise, we'll have to issue the clear contempt.
Lords, they are just taking advantage of the leniency the court has granted.
Yes, no, there's a clear contempt. Yes.
But this is number 9.
Number 9, yes.
Number 8
list together. Number 8 is infructuous.
Yes.
Number 8 will be disposed
Number 8, this matter hasn't been infructuous in view of the subsequent order passed by the division bench on 1/9/2025. Same is closed.
Grateful, my lord. Grateful.
Item number 10.
To 52 are the contempt matters. My humble prayer was to list it along with the MCWPC and not dispose it today.
Where's the miscase?
Lordship, miscase is also listed today.
Well, my lord, the alleged contempt is against the order dated 4/10/2023
We
passing.
just record if you change circumstances, the contempts are closed.
Yes.
We'll give you liberty to.
I'll just obtain instruction, Lordship. Let me just.
How will you obtain contempt between the
Yes.
court and
I understand,
the
Lordship.
thing? Yes. If you to change circumstances which has been brought about by the Mrs. application has been filed, the contempt applications are closed at this stage itself. Yes. And the call disposed of. Yes, let's see the miscase.
53.
Yes.
By way of the last order, Lordship, if Lordship is pleased to see, para 4, Lordship.
Yes.
Registry is directed to make necessary correction in the cost title. Steps to be taken on the respondent number 6.
Have you taken steps?
We have taken steps on number 6, but there is also a respondent number 5, Lordship, which is the Dorbar Shlong. But because of the non-reflecting that in the order, we have not been able to. So that's why I had mentioned it yesterday, Lordship, just to clarify that.
Only for this,
Lordship, yes, the registry did not accept it, Lordship. So there is no order to.
We are a wily customer.
Lordship.
Yes, Mr. S. Deb submitted that as there is no specific direction for steps to be taken in respondent of 5, the same was mentioned, and such matters come to the stop. Next part is noted that in the order dated 9/9/2025, this court had directed that steps be taken on the respondent to 6. Accordingly, the stop ended with the matter. The petitioners also directed step on respondent number 5 just after puja vacation.
So this will carry to item 95.
95.
96.
Obliged.
Is that true? Yes, mediation is that true? Same model. No, right.
Daily
As
list.
per the letter, as per the note, as per the letter, it's not in the office noting हमने क्या letter. हम correct कर दो. As per the note.
Daily list item number 1.
In spite of last order, there is no instruction in this matter.
Where's the officer? See the last order. It was not communicated to them.
We sent this order, ma'am.
You have communicated verbally also. Who's the officer responsible?
The garrison engineer.
Then appear next date. Otherwise, he's here. What is this?
Your Lordship, again they send me one notice. During this pendency, they are doing this kind of things, but they are not replying the writ petition, Your Lordship. They are not filing an affidavit.
When was this sent? This order
12 September.
8/9?
Yes, Your Lordship.
Yes. You're not aware of this, Dr. Mozika?
No, but they are incommunicado.
This court, by order date 8/9/2025, had allowed the respondents 1 week time to file affidavit or to ensure the presence of an officer competent to answer the queries contained in the petition. Stop. Like that. Today, Dr. Mozika submits that they still are still awaiting instructions in the matter, and it is also noted that there is no officer present in court to answer the queries. So, however, next paragraph, Mr. Mia has produced what is this? This is is sent to has produced a communication. Who is this person who signed it?
Assistant garrison engineer. AG.
Under the signature of the assistant garrison engineer, whereby the petitioner has been directed to visit the site for joint measurement with the board of officers to take final information of officers. Stop. But it's not understood under what circumstances this letter has been issued when the order dated 8/9/2025 has specifically directed for affidavit on instructions or the presence of an officer. In this court takes serious view of this matter. Accordingly, it is directed that the concerned officer, that is the garrison engineer, of just give the
garrison engineer Jakham.
Is directed to be present in court on, give a date.
8th, 9th.
Yes, Lordship.
8th or 9th of October.
On 9th October at 10:30 am. Yes. Copy this order to be made over to the learned GSGI for honored communication and compliance.
Right. Obliged.
Item number 2.
But here we are filing affidavit today. In the process of filing.
You receive copy?
My lord, I haven't received as yet. My lord, just
Mosika submits that the affidavit, bring on record other proceedings will be filed in the course of the day.
my lord, I have a small submission here, my lord. My lord, the reason why we had gone under section 9 is to secure my bank guarantee, which we fear would have been encashed. Now, my lord, that being the position here,
You have received interim orders.
we have received interim orders. My lord, a status quo has been given.
Let it come on record, then we will take it up.
Yes,
my lord.
That time we can make a small submission.
My lord, because 11(6)(a) will be confined to seeing the existence of the arbitration
Yes, whether
agreement and not the content in the arbitration agreement.
it's
Highly obliged.
for order. It's up to you.
Item number 3.
This is also for affidavit. I'm praying for 2 weeks time. I'll ensure that we'll file before next day.
Yes.
Lord, we had submitted a list. Maybe my senior can take instructions on that list.
You are insisting on Saurabh Mathur.
Amongst other names, my lord.
Yes, Dr. Muzika peaceful is allowed for a 2 weeks time. That is expected the next date that the name should be finalized by the respondents.
Today there's a new
appoint from ourselves.
My lord.
Today there is a headline, my lord. Mr. Tushar Mehta said that looking at the name of the arbitrator, you can know who are the lawyers and who are the parties.
Who? I didn't see that. Then the court nominate arbitrator.
My lord, if there is no consensus, definitely my lord will exercise powers.
By next day, yes.
Obliged.
Item number 4.
Yes. Yes.
My lord, item number 4, my lord, non-compliance of the order dated 25/9/2024, my lord. Benefit of ACP and MACP to the cipher category.
Oh, it's enter appearance today only.
Yeah, my lord, I have instructions, my lord. It says that there are about 1,000 people involved in this, my lord.
Only 1,000?
About 1,000, my lord. And 20-year-old service records have to be examined, all of them, my lord.
And Dr. M. Mosika has entered appearance on behalf of the respondents today and praise are allowed. You file affidavit.
My lord.
To be allowed to file an affidavit before the next date. Yes, list after so.
Item number 5.
May please your lordship, rejoinder has already been filed.
May please your lordship, may be allowed to file additional affidavit to the rejoinder. Your lordship, there's certain facts that the petitioner brought on record through the rejoinder which needs to be answered, your lordship.
You can't keep on having rejoinder to rejoinder. Can't it be answered by all arguments or by documents you can produce at the time of hearing?
Lordship, that's the instruction received from the university.
Where's Mr. Sen? He's not well.
He's there, your lordship.
He's there in the court.
Yes, your lordship.
You kindly will pass up some time because we can't allow rejoinder to rejoinder. They'll ask him to come, we'll take it up after some time.
Yes, your lordship.
Item number 6.
Lordship, just begging the last question, your lordship, just I was not having this name of the person. So, your lordship, I just
we have excused you that, Mr. Debnath.
Your
That's
lordship,
why. Have you been clear or not?
Your lordship, this method, I just call for the record. What the actual problem there?
I know the exact problem. The problem is that you say that at the time of death of the parents, that disability should be there.
So you will see
that before the death,
this
right?
letter, out of this letter, you will see, I just call the record from the department. What the problem going to see? So today I got it.
No. So not the problem we have to see. The problem is that this person has a permanent disability certificate. The board certified also. You have to overlook the provision CCS rules which says that at the time of demise of the parent, after demise, that he has to be shown to be disabled.
So
or before.
So you will see, yes, I was not having you instruction also after this letter come what the action taken by the here in ARC record, because they are the person to put up the matter. So I got this record today. So you will see, let me have sometimes you will see it will be given a place, and then after that
we'll make them pay costs.
So you will see,
we'll have it on Friday.
So you will see in this matter
Friday
communications given to this petitioner here. in 28th August just to come forward. So it will be given a press and after rectifying all these matters.
I don't understand what you're submitting.
So
Please
you will see
speak
here
slowly.
in this matter.
Yes.
When this letter has come 14/7/2025 and after this was communicated to the petitioner on 28th August 2025, intimating the matters. So you will see in this matter, as because it is not denial anywhere to give the pension. Nowhere.
If you don't deny he's mentally challenged, then why can't you release the pension? Why you making him swim in red tape?
So you will see in this matters, if sometime is given and after this it will be
see the last order. Referring same letter 26/8/25. So today Mr. Debnard has submitted that he has received the records of the 4 weeks has elapsed since the last order. No?
You will see in this matter some.
My lord, here, my lord, it is very important aspect also, my lord, that the petitioner herein, my lord, who is mentally challenged, he is mentally challenged from 3 years old, my lord.
Yes, no, the medical boards already is a permanent.
But this
Yes,
is
my
already, the claimant's unable to earn her livelihood due to stated handicap nature.
So you will see my.
Have you communicated this order?
This is the.
Have you communicated the order to them?
I have already.
Then you make the officer be present next date. What's
Yes,
the
my
officer?
lord.
So you will see here.
See only that you have more time. See by order dated 15/9/2025, this court has granted the respondents 4 weeks time to resolve the matter, feeling which further orders would follow. Stop. As 4 weeks still has not elapsed as yet. So this is matter immediately after purifications. If the matter stands unresolved, the concerned officer to appear in person is to answer. And it's expected on the next date that the issue should be resolved permanently.
Item number
Then
7.
on that day we will.
Highly obliged, my lord.
By way of abundant question. Then we can send him to jail straight away from here.
This is a similar situation for me also.
Highly obliged, my lord.
7.
It is your lordship. Lordship, in this matter we are supposed to file our affidavit in opposition.
You appealed for whom? 5 to 7?
5 to 7.
When did you appeal last date?
It was an oversight, lordship. We had missed the there was a problem with our filings, so we had missed the date.
From the appliance?
From our chamber, lordship. There was a glitch, a snag with our filings.
1 to 4?
Your lordship, I'm making similar prayer.
Your lordship, regarding this respondent number 8, we have already taken a step. However, and we applied the service report. However,
No,
we have
Mr. 8, Mr. Esarindo is appearing. You are appearing.
Lordship, as per the information yes, your lordship, as per the information which I have gotten, number 8, respondent number 8 is a non-existing entity, lordship. There is no such thing as the village information monitoring cell.
Then Mr. Esarindo appeared number 8 last time?
I'm not aware of that, lordship.
It's for the petitioner, your lordship.
Who?
Mr. S. Arlindo.
Then how to record it? What to record it? Who? Oh, yes. Oh, sorry. With regard to praise for. So there's no.
We have applied the service report. We haven't received yet.
No, number 8. This is non-existent.
It's a non-existent entity in the village, lordship. There's no such association.
What's it called?
The Village Information and Monitoring Cell.
Take down. MS Zani non-country correspondence numbers 1 to 4. And Mr. LCM correspond 5 to 6.
5 to 7.
5 to 7. Pray for allowed for the 2 weeks time for affidavit. It is also submitted by Ms. LCM that there is no such entity as has been shown as per number 8. Petitioner to verify the existence of a set for number 8 and report on the next date is
Highly honest.
Item number 8.
File the service affidavit on the these are authorities of MECL, Lordship. Service is
1, 2, 3.
Lordship.
You filed service affidavit.
Lordship, yes.
Where's MS Colney?
These are all authorities of the MEPDCL, Lordship.
And after the service, and after it's been filed indicating service upon the respondents numbers
1, 2, and 3.
1, 2, and 3. However, there's no appearance on their behalf today. Where's the MECL council? You get them?
Lordship, I saw instructions from the law officer, but I haven't received the yes.
But they've informed you.
No, Lordship, I saw instructions from the law officer, but I'm yet to receive any instructions, Lordship. With regards to this matter, I asked them whether notice was received or
So
not.
we'll say that you're entering your parents, give extra copies to you. Yes?
Lordship.
May age karon lang paano mo Afraid. No, everyone side stop. Ms. H. Karan lang, whose present court submits that information has been sought from the respondents, but they yet to receive any instructions. Only this is matter up to 2 weeks.
Answer
for further orders.
8, 9, and 10. 8 to 10, Lordship.
11.
Published. Please, Lordship. I've just received the application for withdrawal of the petition, Lordship.
What is this? You'll withdraw it?
Yes, it is, but liberty to file a fresh Lordship.
Yes, this is you file a miscase for withdrawal?
Yes.
Miscase 251/2025. This application has been filed for withdrawal of the main writ petition WPC number 366/2025. This application is allowed for the reasons stated therein. Miscase is disposed of, and then in the main case, in view of the order passed in MC so and so, the instant writ petition is closed for withdrawal. However, liberty to file a fresh if so advised. Yeah.
12.
Lordship.
Yes.
My lord, this is promotion matter. My lord. Affidavit has not yet filed, my lord.
I'm praying
The
for
fresh
Promotion matter, my lord.
So promotion matter is 3 weeks. Yes.
My lord.
13.
And item number 13 is also promotion matter, my lord, and affidavit in opposition has not yet filed, my lord.
Same order.
My lord. Much approach.
Hearing. Item 16.
Contempt petition, Lord, if your lordships kindly have the petition first, I'll just take your lordships through the order.
Ms. Karola, you are appearing matter?
Lordship, I'm assisting the Advocate General, Lordship.
Where's he?
Lordship is on.
He's on legs?
He's coming now. Lordship, but then, as per my view, Lordship, there's no contempt in this matter, Lordship. Your Lordship's order in the writ petition was to consider the petitioner's service in accordance with law. Lordship, we have considered in accordance with law, Lordship, and we have allowed them to apply for the advertisement, Lordship.
Lord, I'll just read the order, my lord, and just point out.
1 second.
Sir, can I print this? Let's may kindly have the contempt petition. At page 11 is, my lord, the order. Annexure 2. Page 11, my lord.
Yes.
Lord, I'll have to read the entire order as a whole, my lord. So, Lord, this is order dated 5th of September 2023, my lord. I'll start from the first paragraph. Para 1. The writ petitioners, 6 in number, are before this court seeking directions for consideration of their regularization in service by the respondents. The case as put by the petitioners are that pursuant to an advertisement inviting applications for candidates for admission into postgraduate diploma in sericulture, the petitioners, after appearing in the written test and personal interview, were selected to undergo a training. On completion thereof, the petitioners were then appointed on temporary officiating basis to the post of reeling foreman, farm manager, sericulture inspector, with a prescribed pay scale. Number 2, it is noted that in the appointment order at the footnote, it has been provided that the appointee was requested to apply to the Secretary MPSC as soon as the post against which they are serving was advertised for regularization. It has been contended that the petitioners have been serving since 2010, 2012 and 2014 respectively and have not been given any consideration for selection and regularization against the post for which they are serving. Para 3. Mr. So-and-so, counsel for the petitioners, submits that the posts against which the petitioners are serving are presently lying vacant and there should be no hindrance on the part of the respondents to engage in the process of regularization through the MPSC for accommodating the petitioners by way of special recruitment. So what they had sought for is special recruitment. In support of his submission, the learned counsel for the petitioners had referred to an order of this court passed in petition number so-and-so, which he submits to similarly situated petitioners in the same department. On the orders of this court, the process through the MPSC was concluded and subsequently they were afforded appointment. It is finally submitted that the case being similarly situated and in view of the vacancy position of in the department, that the appropriate order be issued to direct the respondents to engage in the process of regularizing the petitioners against the vacant post. Mr. So-and-so, assisted by so-and-so, for the respondents number 1 to 6, has submitted that there can be no legitimate expectation for regularization and further no directions can be issued for the same, inasmuch as it is not a matter of right that the petitioners should be accommodated against the vacant post as prayed for. He further submits that the appointment to the said post should be made by direct recruitment based on merit. He finally submits that no legally enforceable right has been made out by the writ petitioners to warrant any orders from this court and that the writ petition should be dismissed. Para 5. Having heard the learned counsels for the parties and noted the submissions and also the materials on record, it is a fact that a mandamus cannot be issued to direct the respondents to regularize the service of the petitioners. However, in the present case, the circumstances are such that the writ petitioners were appointed against vacant sanction post and were also afforded regular pay scale along with increments, which has all the trappings of regular employment. The case of the petitioner cannot be said to be absolutely without any merit. Also seen the order passed in so-and-so. In that case, however, it is seen that the department had issued a draft advertisement for regularization of service along with an approved list for special recruitment to the post of viewing inspector, which on inaction of the respondents, this court on being approached by the petitioners has issued directions for conclusion of the process as per the draft advertisement. Though this case stands on a different footing, however, one fact that this court cannot ignore and has to consider in terms of appointment and especially the footnote in the appointment letter dated so-and-so, which is similar to the other appointment letters, the same for the sake of convenience is reproduced herein below. Now this is important on the next page. So this is the appointment letter, your lordships. Now the footnote, your lordships, will find at page 16.
Yes.
On the right column, alert, page 16.
Yes.
You are requested to apply to the Secretary MPSC Shillong as soon as the post of manager, sericulture inspector, reeling foreman is advertised by MPSC for regularization of your appointment. The word used in the appointment letter is regularization of your appointment. They didn't stop at advertisement, alert. They say for regularization of your appointment.
Yes.
Now para 6 minute. It is noted in the appointment letter itself, the appointee writ petitioner was requested to apply to the Secretary MPSC as soon as the post was advertised for regularization of the appointment. 7. looking into the situation of the petitioners, that is no doubt they are not possessing any legally enforceable right to seek regularization of the post. But however, your lordship says, but however, in the considered view of this court, their cases deserve some consideration by the petitioners in view of the footnote that has appeared in the respective appointment letter. Accordingly, this writ petition is disposed of at a direction that the respondents consider the case of the writ petitioners by looking at the vacancy position in the department and to take steps in accordance with law to consider their regularization is the word used by your lordships. It is expected that the same is be done expeditiously. So even the footnote says regularization, my lord, and even your lordships have used the word to consider for regularization. Thereafter, my lord, we forwarded the order, my lord, to the department. Now there was no time frame, my lord, given in the order of September 2023. So before the expiry of 1 year, my lord, we then filed this contempt petition. After we filed the contempt petition, my lord, the respondent has then filed the first affidavit, which was filed on 14th of October 2024.
Yes.
14th October 2024 is the first affidavit, my lord. And if your lordships may kindly have page 3, the second paragraph in page 3, my lord. This is where there's a blatant, my lord, contemptuous statement. It is submitted that this honorable court has not given any direction for regularizing the service of the petitioners, nor has this court given a time period for the respondents to consider the regularization of the service of the petitioners. Hence, there is no willful disobedience or violation of this honorable court's order dated 5/9/2023. Moreover, it is submitted that as and when the requirement arises, the department shall appoint the candidates in accordance with law, which is more specifically specified in Rule 7 and Rule 8 of Meghalaya Sericulture Service Rules 2012, and the petitioners may participate in such recruitment in accordance with law. Now, your lordships took exception to this affidavit, my lord, and directed them to file another affidavit. Now, subsequently, my lord, pursuant to that, my lord, they have filed a second affidavit, my lord, which is dated 16th of December 2024.
Yes.
Now, 16th December 2024 affidavit, my lord, says at para 8, my lord, it is humbly submitted that in compliance with the order of this honorable court, the vacancy position in the department was considered, and at present vacancy position in the department is that as against the 14 sanctioned post for direct recruitment, no post is vacant for direct recruitment. So basically, if I take your options back to para 4, just to understand the number of sanctioned posts, para 4 says, my lord, it is humbly submitted that there are 28 sanctioned posts for sericulture so and so. And para 5 says, my lord, that out of these 28 sanctioned posts, 50%, that is 14 posts, are to be filled through direct recruitment, and the other 14 posts are to be filled through promotion. That para 6, my lord, that presently 15 posts out of 28 sanctioned posts are occupied by the candidates, including 6 petitioners who have been appointed on officiating basis. Para 7, my lord, that all the present appointees on 15 posts, including the petitioners, have been appointed beyond the cut-off date of 2007, whereas the cabinet has only approved the regularization of ad hoc employees appointed prior to 2007. And at para 9, my lord, it is humbly submitted that as and when there are any vacancies against the 14 sanctioned posts for direct recruitment, then they are to be filled in accordance with law as per the reservation roster prepared in compliance of the office memorandum dated so and so. So basically, my lord, by this affidavit, what they stated was that there are 28 posts and 14 posts by direct recruitment. So as and when they are advertised, the petitioners can apply for it. This was a statement. Now your lordships again took exception to this and directed them to file another affidavit. Now a third affidavit was filed, my lord, on 28th of July 2025. Your Lordships has the affidavit?
Yes.
Yes, my lord. There, my lord, at page 2, para 2, they reiterate, my lord, that there are 28 posts. Para 3, they reiterate that 50% is for direct recruitment. Para 4, they reiterate that 15 posts are occupied by ad hoc appointees. And at para 5, they say, while considering the circumstances in the instant case, has sought the approval of the personal department with regards to one-time age relaxation for the petitioners and repetition so-and-so. It is further submitted that the personal and administrative reforms department by letter so-and-so has, upon examination of the matter and while considering the circumstances of the petitioner, not objected to the proposal for grant of one-time relaxation of the upper age limit of the petitioners herein. Para 6, it is further submitted that with regards to the issue of roster, which has to be applied against the vacant post, the personal so-and-so department has white letter dated so-and-so accorded approval for reservation roster along with the category-wise breakup of vacancy for the post of sericulture, so-and-so, my lord. Now, para 7 is important, my lord. That it is submitted after receiving due approval from the department with regards to relaxation of age of the petitioners and others similarly situated persons so as to enable them to participate in the recruitment process, my lord. Your Lordships had directed them to consider our regularization, my lord, and not to take part in recruitment process. Recruitment process is a direct recruitment. Now, your Lordships, I'll just take your Lordships to page 6. This is the letter which they have relied upon, which speaks about one-time age relaxation, my lord. So this is the letter issued by the personal department to the Department of Textiles, my lord. Now this speaks about relaxation of age. My lord, para 2, the small Roman 2, my lord.
Yes.
Their appointment letter specifically instructed them to apply for regular recruitment. This is absolutely wrong, my lord. The footnote says advertised by MPSC for regularization of your services. It did not say regular recruitment, my lord. So this is absolutely wrong, my lord. And now, my lord, at page 8, my lord, why we are running against time is because at page 8, your Lordships will see they have now draft advertisement to the MPSC, my lord, to conduct a direct recruitment, my lord, regular recruitment, which will be open to all, my lord.
Yes.
So we are running against time, my lord. So my case is, my lord, before your Lordships, that this is a clear case of contempt, my lord, willfully done, my lord, willfully done. The appointment letter says for regularization. Your Lordships in the order at para 8 says consider regularization of the petitioners. Here what they have done is, my lord, just read only three words, my lord, in accordance with law. Now if they want to get into the merits of what is in accordance with law, my lord, then I'll take your Lordships to a recent judgment, my lord, of the Supreme Court on regularization, my lord. Now, if they say accordance with law, my lord, this is the law laid down by Supreme Court, my lord. This is the latest judgment, my lord, reported in 2025 SEC Online, SC, page 221. This is in the case of Shripal versus Nagar Nigam, Ghaziabad. Now, the relevant portion, your Lordship, I'll just take your Lordships to para 14, my lord. Para 14, my lord.
Yes.
If I may read, para 14. The respondent employer places reliance on Uma Devi Supra to contend that daily wage or temporary employees cannot claim permanent absorption in the absence of statutory rules providing such absorption. However, as frequently reiterated, Uma Devi itself distinguishes between appointments that are illegal and those that are irregular, the latter being eligible for regularization if they meet certain conditions. More importantly, Uma Devi cannot serve as a shield. This is very important. Uma Devi cannot serve as a shield to justify exploitative engagements persisting for years without the employer undertaking legitimate recruitment. Given the record which shows no true contractor-based agreement and a consistent need for permanent horticulture staff, the alleged asserted ban on fresh recruitment through rail cannot justify indefinite daily wage status and continued for unfair practice. Para 15, my lord, in the middle of the page, my lord, this judgment also relies on one judgment, my lord, Jago versus Union of India. This was also a 2024 judgment of the Supreme Court, my lord. So, my lord, in the middle of the page, Jago versus Union of India at para 22, my lord, it was held, my lord, the pervasive misuse of temporary employment contracts as exemplified in this case reflects a broad systemic issue that adversely affects works, rights and job security. In the private sector, the rise of the gig economy has led to an increase in precarious employment arrangements, often characterized by lack of benefits, job security and fair treatment. Such practices have been criticized for exploiting workers and undermining labor standards. Government institutions entrusted to uphold the principles of fairness and justice bear an even greater responsibility to avoid such exploitative employment practice. When the public sector entities engage in misuse of temporary contracts, it not only mirrors the detrimental trends observed in the gig economy, but also sets a concerned precedent that can erode public trust in governmental operations. Then it reproduces para 25. It is a disconnecting reality that temporary employees, particularly in government institutions, often face multifaceted forms of exploitation. While the foundational purpose for temporary contracts may have been to address short-term or seasonal needs, they have increasingly become a mechanism to evade long-term obligations owed to employees. These practices manifest several ways. So, my lord, this has been highlighted, my lord, in bullet points. Yes. Misuse of temporary labor, my lord, arbitrary termination, lack of career progression, using outsourcing as a shield, denial of basic rights and benefits. Then, my lord, at next page, at para 8, sub para Roman 4, my lord.
Para?
Para 18, in the next page. These are the directions issued by the Honorable Supreme Court, my lord, yes, in this particular matter. Now, what is relevant to me is, my lord, sub para Roman 4.
Yes.
So, what was directed by the Honorable Supreme Court, my lord, is the respondent employer is directed to initiate a fair and transparent process for regularizing the appellant workmen within 6 months from the date of reinstatement, duly considering the fact that they have been performing perennial multiple duties akin to permanent post. In assessing regularization, the employer shall not impose educational or procedural criteria retroactively if such requirements were never applied to the appellant's workmen or to the civilly situated regular employees in the past. To the extent that the sanctioned vacancies for such duties exist or are required, the respondent's employer shall expedite all necessary administrative process to ensure that these long-time employees are not indefinitely retained on daily wages contrary to the statutory and equitable norms. So, my lord, why I'm being forced to, my lord, cite this judgment is because, my lord, they are misreading the directions by this honorable court, my lord. They are reading only 3 words, my lord, in accordance with law. So that is why I am compelled, my lord, to produce this judgment, to show this judgment, my lord, that this is the law. Now, my lord, 2 things. Now, even if they say, now what they have done is, my lord, they have, my lord, what they have done is, my lord, they have issued the draft advertisement, my lord, to MPSC, For direct recruitment, my lord, or regular recruitment, we'll say open to all, my lord. Open to all. Now, my lord, yes. Now that is also in accordance with law, my lord. In accordance with law. But whether it is accordance with the order of your lordships. Now that, according to me, my lord, is trying to, my lord, frustrate and, my lord, circumvent the directions of your lordships. Now, my lord, in the recent judgment, my lord, dealing with contempt law, my lord, contempt of court, I'll just cite this judgment, my lord. This is, my lord, the judgment of Seller LLP, my lord, reported in 2024, SSC Online SC 3727, my lord. Relevant paragraphs, my lord, your lordships will find at para 197, my lord. So from 182 onwards, my lord, this judgment deals with contempt. But what is relevant, my lord, which I will read, is from para 197 onwards, my lord, up to para 202. So, my lord, in para 197, the Honorable Supreme Court says, my lord, contempt jurisdiction exists to preserve the majesty, sanctity of the law. Courts are the guardians of justice, and their decisions must command respect and compliance to ensure proper functioning of society. When individuals or entities challenge the authority of courts through the willful disobedience or obstructive behavior, they undermine the rule of law and create the risk of anarchy. Contempt serves as a mechanism to protect the integrity of courts, ensuring that they remain a symbol of fairness, impartiality, and accountability. When judicial orders are openly flouted or court proceedings are disrespected, it sends a signal that the rule of law is ineffective, leading to a loss of trust in the system. Judicial decisions must remain unimpaired, free from external pressures, manipulation, or circumvention. Acts that attempt to mislead the court, obstruct its functioning, or frustrate the decisions distort the process of justice and would amount to contempt. The contempt jurisdiction of this court cannot be construed by any formula or rigid approach merely because there is no prohibitory order or no specific direction issued. The same would not mean that the parties cannot be held guilty of contempt. The contempt jurisdiction of the courts extends beyond the mere disobedience of explicit orders or prohibitory directions issued by the court. Even in the absence of such specific mandates, the deliberate conduct of parties amid at frustrating court proceedings or circumventing its eventual decision may amount to contempt. This is because such actions strike at the heart of the judicial process, undermining its authority and obstructing its ability to deliver justice effectively. The authority of courts must be respected not only in the letter or of their orders, but also in the broader spirit of the proceedings before them. Any contumacious conduct of the parties to bypass or nullify the decision of the court or render it ineffective or to frustrate the proceedings of the court or to ensure any undue advantage thereof would amount to contempt. Attempt to sidestep the court's jurisdiction or manipulate the course of litigation through dishonest or obstructive conduct or malign or distort the decisions of the court would inevitably tantamount to contempt sans any prohibitory order of the direction to such effect. 201. This is important. Thus, the mere conduct of parties aimed at frustrating the court proceedings or circumventing its directions, even without any explicit prohibitory order, constitutes contempt. Such actions interference with administration of justice and undermine the respect and authority of judiciary and threaten the rule of law. So, this is what I'm trying to say, Malad. In this particular case, what they're trying to do is, Malad, by using 3 words, Malad, they're trying to circumvent and frustrate the orders of this Honorable Court, Malad. That is my submission.
Yes, sir. Yes, my lord. I think we'll issue notice of contempt.
Your Lordship, kindly hear me and then. Lordship,
because the order is very, it's done the different footing this case altogether. They can't take shelter of, general treatment.
Yes, Your Lordship, kindly hear me.
Answer will give you a chance to show cause again. We'll issue notice of contempt.
Your Lordship,
and
hear
whatever.
I bow down, my Lord. I bow down to Your Lordship's directions.
Give me 3 chances to file affidavits.
Yes, my Lord.
It's not that the court has not been very.
Yes, my
Lord.
I'm
given
grateful.
you enough.
Yes, my Lord. Your Lordship I'm grateful, my Lord. Let me place my submission, Your Lordship. Thereafter, whatever Your Lordship is right, my Lord. Your Lordship, kindly see the contempt is alleged of the order of Your Lordship of 5th September 23, my Lord. And I'm grateful my friend has read the whole judgment, my Lord. Yeah. Kindly see Your Lordship's order, my Lord, paragraph 5 at page 13.
Yes.
Having heard the learned counsel of the parties and noted the submission as also the materials on record, it is a fact that a mandamus cannot be sued to direct the respondent to regularize the service of the respondent. So this is one finding. My Lord has said that Your Lordship will not, if Your Lordship...
General circumstances...
Yes, my Lord. I bow down. I bow down, my Lord. I am not saying, my Lord, Your Lordship, because only the difficulty, if Your Lordship would have directed them to regularize, we would not have difficulty in regularizing or taking whatever. That is, if Your Lordship says that you consider them in accordance with law, what do I do as a state, my Lord? Whether I apply Article 14, Article 15 or 16 or not, my Lord? Because those are also part of the law. My question is this, my Lord, to my friend, that he says that I have willfully disobeyed the order of this Honorable Court. Your Lordship, and then Your Lordship, however, in the present case, circumstances are such that were appointed against the vacant post and were afforded regular pay scale along with incumbent and has all trapping of regular employment, case cannot be said to be absolutely without any merit. As seen from the order of this, however, seeing the department issued draft advertisement with an approved list of so and so, my Lord, and they especially now though this case stands on different footing, Your Lordship distinguishes the previous case, and then court cannot ignore and has to consider is the terms of appointment, especially the footnote in the appointment letter, which is similar to other appointment letter. And then Your Lordship sees the terms of the appointment letter, and after seeing the appointment letter, what Your Lordship direct the government, state, to do what, my Lord? The appointment was requested to apply secretary so and so advertisement. Looking now paragraph 7, which my Lord, looking into the situation of petitioner, there is no doubt that they are not possessing any legal enforceable right to seek regularization to the post. But however, considered view of this code can deserve some consideration, my Lord. Your Lordship has granted some consideration. Your Lordship has directed them regularized. We would have regularized, my Lord. Some consideration in view of the footnote which appeared respectively upon.
We cannot direct regularization. No, can direct for promotion.
No, Your Lordship.
No, can be direct.
No, Your Lordship will. Your Lordship
why did you appeal in this order?
No, my Lord. That is why I am coming. I am coming. I am not satisfied. Your Lordship should have said, because Your Lordship, my humble submission, my Lord, is Your Lord, if there is a direction, we say that you consider and regularize
Can there
them.
be any
Consider
outside the law?
No, my Lord. See if the direction and then kindly see paragraph 8, my Lord. My difficulty is twofold. If that is also clarified, we have no difficulty, my Lord. We will regularize them. But the question is, my Lord, in department, take steps in accordance with law to consider their regularization. My friend is saying that these 3 words have got no meaning. I need not follow law. Either what do I do as a state, my Lord? If Your Lordship clarifies that that law is not required to be followed, now Your Lordship will see what is the law. Law is Article 14, 15, 16. Now there is a roster, my Lord, which is filed, my Lord. If Your Lordship will see my affidavit at page 8, Annexure 3, my Lord. And they are the 6 petitioners, my Lord. And they are 1450.
The last affidavit.
Your Lordship, the affidavit is dated 28 July, my Lord. 28 July, my Lord. Now, my Lord, these are the posts, my Lord. 14, Khasi Jaintia 6, Garo 5, unreserved 2, OBC ST 1. So this is the.
Yes.
So now, my Lord, if the question which I beseech Your Lordship to consider, my Lord, that what my friend says that in accordance with law has to be ignored.
That's in accordance with law. Everything should be in accordance with law.
Yes, my Lord. So my friend's argument,
so Your Lordship, why has this court taken exception to their case? It's not a simple case realization. It has taken exception, seen there, it's distinguished with other case because the appointment order itself.
Yes, Lord.
They have not come through an irregular or they've been selected.
Yes, Lord.
They're sent by the Department
I bow down,
of Training. Yes, been appointed, and in the footnote it says that the moment there's vacancy, you apply and it will be regularized. against the post. Let's go to the 3F and a 4D kind of situation.
No, my lord, the slightly different nuanced argument which I am trying to make, my lord. Nuanced argument which I am trying to make is.
I'm sorry.
No, my lord, let me just let me hear, my lord. My friend has placed everything. I just want.
Where's the form in the High Court rules?
Your lordship, kindly hear me, my lord. Kindly give me 2 minutes more, my lord, because he has cited 2 judgments. I want your lordship not giving me opportunity. That much I will say.
Yes, okay.
Please give me opportunity. Then I have no issue, my lord.
5 minutes.
No, I will. Whatever my friend cited 2 judgments, I need to deal with, my lord. Otherwise, whatever your lordship, if your lordship feels that.
No. Okay, you answer.
But I have no. My lord, the only thing which I am trying to say before your lordship is this: that if your lordship says that direction is crystal clear to the government and government has mistaken by reading these 3 words, then, my lord, my submission is that it was a bona fide mistake on my part. If the order clarifies, contempt order clarifies that you have to do it, you have to regularize them, because at 6 of them are there, I have to regularize them because if I issue advertisement, my lord, I issue advertisement for what, my lord? The question is, I issued the other day, in 2 days back only, I argued a contempt petition for private party before Honorable Supreme Court. Direction was clear. The Honorable Supreme Court said you implement it within 4 weeks. That was the order which I achieved for private party also, my lord. But the question which falls for your lordship consideration is if there is a direction, some consideration in accordance with law, that was creating trouble for the department. If whether I should apply roster or not to apply roster, my lord, whether I should apply this because I should have the advertisement for these posts or not to have advertisement, because if I have to regularize 6 of them only, then the problem is that there are 8 other posts also who are not before your lordship.
See, the thing is that, Mr. Advocate General, you can, as you have done in other cases, you can have a special,
my lord, I have
review
a submission
for 6 of them.
I have one submission to make.
Unless they unfit in a way that it can be accommodated, fine. But the thing is that if the orders of that we didn't ask for draft advertisement to advertise for all the posts.
No, because
the thing is that now the thing comes to graduation, consider it. If they can't be realized by special recruitment, then you spell it out.
Special recruitment would mean, my lord, special recruitment.
That is what you have resorted to in other cases.
No, my lord, the question is because they were there prior to 2000, because 2007-8, my lord, there is
is that not in accordance with law?
If your lordship will see
now if you see in accordance with law, that means that it cannot be regularized.
No, they will be regularized. There are certain relaxations which will be given. 202. If your lordship will see,
I don't argue with you. The thing is that now, by own footnote, you have given a condition, right? And fine, that's you just keep that in mind. Number 2, now 2007 case also a policy decision. Same thing. It's a condition. Those people have been appointed before, special recruitment, regularized by capitalization, and they have a special you appear for DSC or MPSC. Same situation is prevailing here. It's only that you are resisting it.
No, I am not resisting, my lord. If your lordship will clarify in the contempt order, we will regularize. Why should we?
Can't clarify contempt.
No, because the only difficulty, if my lord, if your lordship will kindly see page 20, paragraph 202 of the judgment of my friend. I am grateful to my friend who has placed the judgment before your lordship.
Yes.
Paragraph 202.
Mr. Advocate General, we give you. Can they be more restrained than allowing 3 affidavits?
No, I understand, my lord. Because if the problem is, however, at the same time, the power of contempt ought to be exercised sparingly and with caution and care. It operates with the string of caution, and unless otherwise satisfied beyond doubt, it would neither be fair nor reasonable to the courts to resort to such power.
See,
I'm just coming to the relevant line. No, I'm coming to the relevant line, my lord. The standard of proof required before a person is held guilty of committing contempt of court must be beyond all reasonable doubt, my lord. That is my submission is, if your lordship says that it is, my doubt is this much only. Now your lordship will see 203, my lord, 203 which I am placing it. This court, while exercising its contempt jurisdiction, must remain circumspect, more particularly where there exists a possibility of order being amenable to more than one interpretation. My submission on this issue only, my lord, in so and so, my lord, it was held that order does not contain any specific direction regarding matter, or if there is any ambiguity in the direction issued therein, it would be appropriate to direct the parties to approach the court with disposed of matter for necessary clarification of the order, instead of court exercising its contempt jurisdiction, thereby taking upon the power to decide the original proceeding in a manner not dealt with, the court passing the judgment and order. Relevant observations read, my lord, highlight: if judgment and order does not contain any specific direction regarding a matter, or if there is any ambiguity in direction issued therein, then it will be better to direct the parties to approach the court which disposed of the matter for clarification of the order, instead of court exercising contempt jurisdiction.
That has not been done.
So
three affidavits have been filed.
No, my lord, in the direction, if your lordship will say that, if what I was praying, my lord, if those two, I have to, like in other matters, your lordship has directed issue the advertisement for their regularization. We have done it and we have regularized them, my lord. These three words created some issue on our part, my lord, and there was no, if those words are also omitted now, that regularize 6 of them, my lord, we have no issue at all, my lord.
We cannot direct for.
No, my lord, this much only.
Court will not regularize.
No, this much.
Moment. See,
no, I'm not making any submission, my lord. I'm trying to find out the solution to the problem. Solution is, my lord, I'm only saying solution which I'm urging your lordship is that even this, because if I follow law, then I'm in, if I don't follow law, I'm in contempt. If I follow law, I'm in contempt, my lord. My question is, because
why we follow law, I'll be in contempt.
And your lordship will see the direction, paragraph 70, page 17.
The Contempt law comes every.
So now, what do I do, my lord? That is the problem. If those words would not have been there, I would not have any issue.
In a Contempt law, given you enough latitude.
Maybe you take a step, my lord, because in affidavit will not override the direction of your lordship. According to the writ petition, is disposed of the direction that respondent consider petitioner looking vacancy position department. This must be have no, and take steps in accordance with law to consider, my lord. This because law is, my lord, I have to apply, because how will I fill they are, for example, they are from Garo community and I have to fill them against the Khasi community, or I have to fill them if they are in the roster, if they are not, because I have to break the roster, my lord.
See, Mr. RP, that thing is very simple. There's nothing that needs clarification also, because this order came from this court because of the very appointment order which is given to them. That's all. Simple as that. That's why this court was directed for consideration. Because consider, you have to consider
what I will
everything stems from everything stems from appointment order. Whatever rights that a person employee has stems from.
I put a question to myself, my lord. I put a question
from the appointment order. And if the appointment order gives you certain rights or certain expectations, you have to fulfill that. That's all. So it goes back to appointment order.
May I respond
if
to
there
what
no rights are nothing is there, then nothing is there.
May I respond to what is falling from your lordship is that appointment order contains that kind of stipulation. Therefore, I am bound by the stipulation in the appointment letter, my lord. Kindly appreciate this fact, my lord, that appointment letters cannot override the constitutional and the other. If they appoint, so these are the contractual letters, my lord. Contract can take away Article 15, 16, whether I am required to apply the reservation in the public employment or not, my lord. If the appointment letter says, my lord, so therefore this is the problem which we were having, my lord. If your lordship feels that they have to be
arguing this matter, because you can see it very well for itself. It's clear as daylight. I what has happened here. So we had given enough opportunity, 3 affidavits to clarify. But then now you're making this submission, which we made initially. Instead of being,
my lord. So then in that case, solution possibly, my lord, is a solution possibly is, my lord. So far as for the 6th candidate, my lord, because, my lord, problem which will be now, because only 6 of them are before your lordship. There are 14 vacancies, my lord. Now for 6 of them, I will ask the department to have separate recruitment.
That's what
and for rest, my lord, to that much, your lord, to clarify that so far as the other appointments are.
General, from the beginning, they have been appointed sanctioned posts.
Others are also appointed.
If they appointed outside the cadre or beyond the posts which are there in the department, we can understand.
My lord, the problem is that there are 14 of them, 8 of them. So
you have a special recruitment.
Only for 6, my lord.
Yes.
Only for 6, my lord.
Otherwise, what's the chapter?
Only for 6, my lord.
For 6, my lord.
Only for 6.
I have come to
only for 6 million. What I will do, I will advise the department to segregate the entire post from 18. Your lordship.
Other issue notice of contempt.
Yeah, I'll advise the department. But only thing, my lord, I didn't get the opportunity to assist your lordship in this matter initially because these terms and conditions cannot bind the thing is that. But this is the order which is final.
Have you seen how patient the court has been?
I understand.
Now we have 3 affidavits.
I will
anywhere in the country where 3 affidavits are allowed to clarify the position?
No, my lord, give me time. I will get the issue clarified, my lord.
Yes, the matter has been heard at length. However, arbitral praise that may be allowed. How much time?
2 weeks time, my
2
lord.
weeks time to resolve the matter. Yes. Otherwise we'll have no choice.
26.
Yes. Yes.
May I please, Lordship? Lordship, this matter regarding the recruitment of pharmacy post, my lord. Lordship.
Pharmacy post?
Yes, my lord. The advertisement was issued, my lord.
Where's the advertisement?
At page 15, my lord.
Page?
Page 15, 1-5, Annexure 1 on 19/7/2024. 19/7/2024 advertise was issued, my lord. In that advertisement, my lord, have the page 15, my lord? Yes. My lord, at serial number 8, West Garo Hills, the number of post vacant is 3, my lord.
Pharmacist 3. Okay.
Yes, my lord. Now come to page 16, my lord. The paragraph number 13, which specifically states that, my lord. May I read, my lord? The post of the district above will be filled up by the candidates belonging to the particular district as declared by them in the application forms. In case where there are no eligible candidates from the particular district, then the vacant post of the district will be filled by candidates from amongst the general merit list irrespective of their permanent residential address. I am agreed with this, my lord, because when I fill the form, my lord, I am from West Garo Hills, my lord. I appeared in the written examination in the West Garo Hills, Tura, my lord. Then the practical exams also held in Tura, my lord. And in the district-wise list, my lord, the 3 candidates were selected, my lord. Now, when the merit list were prepared, they prepared the overall entire state merit list they have prepared. Thereby, I am affected, my lord. I am out from the list, my lord.
Meaning?
Meaning, my lord, the game of the rule has been set up in advertisement, my lord. The procedure of the game, my lord. The
rules of the game, not
rules
the game
of the
rule.
My lord, rules of the game. Sorry, my lord. My lord, yes, my lord.
You confused me.
My lord, yeah, my lord, I am extremely sorry,
Yes.
my lord.
Yes.
As per 13 of the advertisement, the candidate would have been selected district-wise, my lord. After the recruitment is initiated, written examination and then, my lord, practical examination, they cannot change the rule, my lord. I am agreed with that, my lord. And now, my lord, in the select list.
Now, when you say the rules of the game have changed,
yes, my lord.
Now you've been left out in what manner? There are people who are meritorious than you who have been given the post in Garo Hills.
My lord.
So your contention is that should be compartmentalized.
My contention.
You advertise 3 vacancies for Garo, only separate this with Garo Hills.
My lord, as per the advertisement, as per the para 13 of the advertisement, my lord, kindly see, the post of the district above will be filled up by the candidates belonging to the particular district, my lord. Now in the West Garo Hills, one candidate who were given appointment, Nasreen Abdin, she is from Southwest Garo Hills. Though she got higher number compared to the petitioner, but in the West Garo Hills, 3 candidates were selected. And I am also one of them, my lord.
You are selected?
My lord, as per the merit list, as per the numbers, I have been selected, my lord, because I have qualified the written examination and I have qualified in the practical examination, my lord. Though in the merit list, where they have I have impugned, my lord, the list, my lord, the final list, my lord.
That is?
At page, my lord, 31, my lord. Page 31. My lord, page 30, annexure 7 starts from the notice. That is the final notice they have prepared. Kindly page, sorry, my lord,
but their pass marks is not merit. So they got pass marks.
My lord, only they have in the now item 4 pharmacists serial number 1 to 21 were selected, my lord. Next page, my lord. The candidates.
Your number.
My number is at 30, my lord. Inamul Haq, my lord. I secured in the written examination 47.
47.
And then, my lord, in the practical exams I secured 11. And total is 58, my lord.
And then where's that this Nasin Abidin she got?
My lord, as at serial number 16. 16, my lord.
Yes, you got 60.
She got 60, but she is from Southwest Garo Hills.
How do you know that?
My lord,
she's appearing here.
No, she is not appearing.
Then?
Because I have been instructed by the petitioner. She's been posted at Fulbury Hospital. But as per my instruction, she is from Southwest Garo Hills, my lord.
No, I mean, you have not made a party?
No, because when I file, my lord, they have not been appointed. My lord, when I file the writ petition, I pray for the stay of the...
Then you have to complete, you can't have, you're challenging her appointment.
No, I'm not challenging her appointment. I'm just giving, my lord, submitting before this court, my lord. Because the rules which is set up, my lord, has been violated.
Finds that you have a very good case. And we're going to rule in your favor. Now, any orders that will flow will affect them adversely, correct?
My lord.
Then what? So put yourself in her position. You're happily working in one corner. Somewhere suddenly a court order comes, you have to stop working.
I agree, my lord. I agree. Then, when I filed the petition,
exactly. Now
that time appointment were not.
You should have brought it to the record of the court by affidavit or something.
My lord,
an application.
My lord, my petitioner has instructed that she is from Southwest Garo Hills. So
no, won't it affect her?
My lord, if order goes to, she will affect, my lord. My lord,
kindly
allow us to then make her party, my lord, implead, my lord.
Yes, Mr. S.K. Hassan, at the time of hearing, submits that as appointment orders have since been issued, we be allowed to implead the concerned persons as party respondents.
My lord, yes.
Yes, prayers allowed.
My lord.
Yes, after 3 weeks. Yes.
My lord.
How do you expect to carry on the hearing then?
My lord, I bow down, my lord, to that, my lord.
You're already a seasoned lawyer now. You're not an amateur anymore.
No, my lord, I bow down, my lord.
28.
Highly obliged, my lord.
Where's Dr. Yes.
My lord, the simple prayer in this repetition second round of litigation, my lord. Revision of the retirement benefit only, my lord.
Yes, MS Milcham.
DSJ is coming now.
It's coming.
Petitioner can start.
What outstanding pay allowances has it been?
My lord, first order this Honorable High Court has directed, that is the annexure 4, my lord, page 51.
Yes. Page 51.
And, yes, my lord, 51, my lord. And relevant portion as page number 53, my lord.
53?
3, my lord. 53, yes. Paragraph number 4. During the course of the arguments, both learned counsel presented the...
Is a contempt?
No, my lord. This is repetition, my lord.
Yes.
Passed in WPC so-and-so, extending the relief to the similarly placed persons. Like the petitioner, Dr. N. Mojika submitted that the relief granted to the said writ petition will be extended to the present writ petitioner also. Learned counsel for the petitioner fairly submitted that since there appears in the hydrants on account of the principle of res judicata, the benefit of the orders dated so-and-so passed in WPC number so-and-so may be extended to the petitioner, my lord. As per the respondent have agreed to the extent the benefit of the order for the present writ petition, if otherwise found eligible, the present writ petition is disposed of by directing the respondent to complete the exercise in terms of the order.
This order covers your case also. You
yes,
see?
My lord.
Where Dr. Mojika?
He's coming, Lord.
We understand he's coming, but he's not here yet.
Thereafter, my lord, kindly come to their affidavit, my lord.
This is the he is the petitioner here in this earlier petition also. 478.
Yes, my lord. Yes, my lord. So, my lord, then come to their affidavit, my lord.
Yes.
Page number 10, my lord. The service which I have completed during the interim period, my lord, that amount has been recovered by the respondent authority. That amount has been refunded to the respondent authority, my lord, according to this table, my lord.
What recovered this?
Where is that?
Then page number 10, my lord, of their affidavit.
In compliance regime audit upon a granted appearance for a period is served after the all details mentioned as under.
Yes.
Okay.
That amount has been refunded to the writ petitioner, my lord.
Yes.
Thereafter, my lord, page number 11.
Yes.
Is that another table, my lord? That pay.
No, the thing is that did you retire before the implementation of the 7th pay commission?
7th retirement order.
Before after.
Before the retirement order has been issued before the 7th pay commission, my lord.
Then you won't be entitled to. How will be entitled to the benefits of the 7th pay commission?
Petitioner approached before this honorable court. Honorable court has granted the interim protection to the petitioner, and then after the batch of writ petitions were dismissed on 15 March 2016, my lord. Thereafter, all petitioners were dismissed from service on 15 March 2016. And as per this order, my lord, all pay and entire pay and allowances has been given to the petitioner up to 15 March 2016.
Good. Then you're given the 7th pay commission benefits.
And then after 7th pay commission, according to 7th pay commission, my pay has been revised, my lord.
Okay.
But
then
retirement benefit, my lord, that is my prayer is only. Kindly come to page number 20 of their affidavit, my lord.
Okay.
Their affidavit, they have annexed my PPO number of all the writ petitioner, my lord. They have annexed the PPO number. Kindly see page number 20, my lord.
Yes.
Revised pension per month.
Yes.
My lord, serial number 1, revised basic pension with effect from 1st January 16.
Yes.
Then, my lord, come to serial number 4, my lord.
Yes.
Amount of differential commutation payable, no change.
Meaning?
That has not been revised. And second thing is, my lord, additional death retirement gratuity is also not revised, my lord. My prayer is only that, my lord.
Yes, Dr. Mujika.
Lots of seen. They were retired compulsorily before 1116, my lord. They came before this honorable court.
Benefits of 7th pay commission.
They came before this honorable court. Interim orders were passed, and eventually the writ petitions were dismissed, my lord. So the question now is their date of initial, because ultimately writ petitions were dismissed, my lord. So their termination with effect from a date prior to implementation of 7th pay commission was upheld. Now only for the purpose of for the period they served after interim orders, this honorable court directed to pay them salary, but that will not amount to extension of their date of retirement, my lord. That's the only question, my lord. Because they served.
Where's the petition where they dismissed, where the dismissal upheld? Where's the order?
I have the order.
Is it annexed?
They have not annexed order.
Why not annexed it, Mr. Kumar?
My lord, that has not been annexed, my lord.
Why?
68 writ petition. Then, my lord, I may be allowed to file additional affidavit. Then I will.
Because that changes the whole case, the whole complexion of the case. We are under the impression that.
Actually, my lord, batch of 68 writ petitions were dismissed.
You file only one.
March 2016.
Yeah, but they are dismissed together in one order. Then you produce the order.
Yes, in one order.
Please have the order with him. Where the operative part?
Last one paragraph.
Last
paragraph.
That's only operative part.
Well, they were compulsory to retire on low medical category grounds, my lord. And the learned single judge held that this fitness of armed personnel is very important, and unfit people cannot be retained in service.
You didn't appeal against this order?
They appealed, my lord.
Somebody
has some others they appealed, my lord.
Succeeded.
They succeeded. But these are the petitioners who filed appeal. And that's how my lordship kindly sees the order passed by Justice Vaidyanathan, my lord. Even that is not in it for them.
2-5, order is there.
Yes, this order is there. So this honorable court only directed that pay the salaries for the period they served under the interim orders. And my lord, lordship kindly sees page 10 of my affidavit, my lord. The dates are available here. Page 10 of the affidavit, lordship kindly sees.
Yes.
The date of retirement was 1/6/2015, my lord. And under the interim order, they served from 1/6/15 till the dismissal of the writ person, that was 15/3/2016. So for this period, they are paid there. So my our case is that by
dismissal of pension will be prior to date of
on the date of
to 1/6/2015.
No,
must be drawn on the date.
Only because they served under the interim order, that will not extend the date of retirement. Well, that's our case, my lord.
Yes.
My lord, we have served up to 15.
Just take an authority. Take an authority, Mr. Kumar. I'll give you time. After puja, I bring authority. Then we will.
My lord.
Yes. On a pray Mr. Kumar who prays, we have to present authorities. List after puja. Otherwise, the case is very clear.
Only that's only issue, my lord.
Yes.
Item 5.
My lord. Deep your lordship.
Mr. Sen, it was submitted by. Why you want to rejoin the rejoinder? How many rejoinders can be allowed?
It should not be. Normally, it should not be. Normally, I never do. Now, what happened? If you
That's why I refuse the matter again.
Writ petition. Writ petition, main thing was focused in the body of the writ petition, regularization. Those batches of cases, my lord, I have mentioned in my batches of cases filed, my lord, dismissed, matter went for appeal. Appeal was withdrawn. Some appeal, even the division benches said you should not come back with the same issues before the court. So those things I have stated. Now they have filed a, my lord, rejoinder affidavit. Now they are highlighting something else. Now they are talking about some kind of settlement we have made before the level court regarding equal pay for equal work. So that was not that we highlighted, my lord, in the writ petition. So that one too, my lord, we are under obligation to do it, provided, my lord, they are discharging the similar duty.
Now what settlement have they annexed? Then you file, we won't say rejoinder. Mr. SN is allowed to file an additional affidavit. Yes, to clarify the additional affidavit to bring in additional facts in support of his case. Please allowed his approval application to bring in. Otherwise, if that's the case.
29.
29, my lord, is that Bijini complex.
Which one?
The Bijini complex.
That case, your lordship, let me have instruction, your lordship, whether any talk has been initiated or not, your lordship. It will come after 2 weeks, your lordship.
Yes, on the prayer the party this is a matter after.
Well, there is an interim order.
Interim orders shall continue till next day.
Oblige you.
How do you